2019 CR 12495 State versus Taymor McIntyre. We're going to have parties announced.
Jason Terry, Hayden Galloway for the state, Your Honor.
John Hunter and Thomas Lang for Mr. McIntyre, Your Honor. He's present in the courtroom.
And are parties ready to proceed?
Yes, Your Honor.
One moment, Your Honor.
Yes.
I'm going to need to call a witness out of my intended lineup, so let me
Sure.
just go see if she's in the hallway.
All right. Cindy, can you do a test on yours? Just write the word test so I can make sure it's coming through on my end. Because I think I'm connected. Yes, thank you. State, the case that's scheduled for trial, 2025 CR 001491.
about, she said 10 or 15 minutes,
Okay,
if the court would indulge us that.
sure.
Thank you.
Judge, I'm halfway through, it's 45 slides. We would be, at this point, just opposed to it. It seems that some of the material may not be relevant that he can testify to, and it may be misleading to the jury because there's very big portions explaining many different attributes to it that don't have any relevance with this particular defendant.
If they would like to proffer it for the record, we can proffer the testimony for the record. And
Well, I haven't seen the slides, so show me the slides.
yes, Your Honor, can I email it to the court?
Yes. Any objections to them emailing it to the court?
No, Your Honor.
Oh, everyone, please be seated.
I believe it's sent, Your Honor.
All right. I'm waiting for it.
They're doing over there counting Wi-Fi.
Deputy Laura?
No?
Yeah. They have something that they want to go over, so.
All right, I'll let them have them go sit down again.
All right, thank you. All right, we're on the record, and we're going to go over this PowerPoint. So, if everyone could get on the same page that the court is on, the court is in receipt of the PowerPoint that I believe the witness, Dr. Fabian, would like to present to the jurors. All right, first slide. Any objections to the first slide?
No, Your Honor.
Second slide, any objections?
No.
Third slide, any objections?
No, Your Honor.
Fourth slide, any objections?
Yes, Your Honor.
All right, what are the objections to slide number 4?
It seems that they're just putting down his testimony in writing, and just at this point, hearsay, Your Honor.
All right.
It's a demonstrative, Your Honor. We're not offering it for the jury to take back. The state has several demonstrative exhibits we didn't object to, but I don't think that we could have.
All right, so here's the thing. So both parties will know. Objections that people made or did not make to other sides, that's not a factor in my consideration on whether or not something should be admitted. So, with regards to this slide that we're on now, state it appears that it's related to, just one moment. Deputy Laura, I'm getting feedback from the witness thing. What's that turned off?
Okay.
All right, thank you. It appears to the court that these are risk factors that are specifically related to the defendant. Is that correct? And Dr. Fabian, you can unmute yourself, please. And I'm going to go ahead and swear you in. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I swear.
All right, you can lower your hand, state your name for the record.
Yes, John Matthew Fabian.
All right, is there going to be any objections to this witness appearing by Zoom?
No, Your Honor.
No, Your Honor, it's on our request. Thank you.
All right. Any objections, because I want us to get to the point of these slides, any objection to the court asking the witness a couple of questions with regards to these slides so that I can see whether or not they should be admitted as demonstrative?
I have no objection.
No objection.
All right, so the slide I'm looking at that says Taymor McIntyre mitigation themes, is that related to this defendant specifically?
Yes.
All right, so with regards to that, it appears that it is not demonstrative, it is testimony that he is going to be given about your client. So if it were a general slide about, we look at risk factors among adolescents, that would be fine, but this slide appears that it's specific testimony, so the objection to that slide is going to be sustained by the state. Then with regards to...
I'm so sorry, Your Honor, I got off. The slide titled Taymor McIntyre Mitigation Themes,
Yes.
you're saying is not admissible? Or
No,
not?
because that's his testimony. It's not a demonstrative, it's his specific testimony about your client. So that slide will be removed.
Dr. Fabian, will you be able to remove the slides from, since you were going to share the PowerPoint through Zoom, will you be able to remove the slides as the judge instructs?
Yeah.
Okay, so that one, number 4, the state's objection to that one will be sustained. Any objection to slide 5?
Objection, I don't think the relevance.
All right, what is the relevance, state, to the Office of Juvenile Justice and Delinquency Prevention? That's sealed.
Sorry,
what is
are you asking Dr. Fabian?
Yes, no, I'm asking you, counsel, because it just appears that this is a slide with a seal on it.
Dr. Fabian, could you advise as to why that slide is in your PowerPoint presentation?
Yeah, it is the author of the next slide.
All right, then the objection to that slide, number 5, that will be overruled. With regards to number 6, are these factors that you look at or that the author looks at in making a determination about a defendant's propensity or state in life, for want of a better word? Are these factors you're considering?
Yes, they are part of my testimony, so.
Dr. Fabian, are these things that are generally matters that you look into when you're making a forensic assessment of someone, or are they specific to Mr. McIntyre?
Both.
All right, so this slide number 6, is this specific to Mr. McIntyre, or is this just generally all of the factors that you look into?
No, I mean, well, there are factors when we're dealing with a juvenile that's charged with homicide, but they apply exactly to his case.
All right, number 6, state that will be overruled. Number 7, that will be overruled, that will be allowed. Number 8, that will be allowed. Number 9, what are the objections to 9, state?
Your Honor, it seems at some point that some, I mean, as I read through these,
Yes.
they get repetitive. So I really like, it's just repetitive and being bolstering.
All right. So number 9, if you can remove number 9.
Okay.
Number 10, that will be allowed. Number 11 remains. Number 12 remains.
Your Honor?
Yes.
On that one?
Yes.
I see that there's X's at the end of some of these, and there's not X's on some, so I believe this is going to be direct testimony.
Is number 12, Dr. Fabian, is that direct testimony?
These are the 10 adverse childhood experience risk factors, and the 8 that are X apply to the defendant.
All right, so that'll need to be removed.
Okay.
And that's not saying that you can't testify if that is your testimony, but it just can't be given as a slide, because then it's not demonstrative. Number 13 is
Well,
that...
and I'm sorry, Your Honor, you want me to just get rid of the X's and keep it no 8 and just have the 10 just as those factors?
I mean, if you want to say that, though, I mean, I don't know what your testimony per se will be. I have an idea because I've seen you testify before. But state if he removes the X's.
I guess, Your Honor, then it'd be repetitive.
All right, so yes, if you'll remove slide number 12, please.
Repetitive, I'm sorry, to what? Because I don't have these factors on.
Oh, that's okay. If you just remove slide 12.
Okay.
Number 13, that remains. 14 remains.
Judge,
Yes.
I guess, I don't know, just that, I don't want to rehash and I'll stop after this, but on this one, it just says life expectancy. I don't understand how that's even relevant to these proceedings.
It's relevant because someone is going to be sentenced for a lengthy period of time, may die in prison, and that needs to be a factor that's considered.
Why? I don't think it is whether someone, their mortality rate, is that a factor in sentencing? Why would you say that?
I would submit that it is because the question about how someone fares in prison, how their health will be handled in prison, do we expect that they will decline at a more precipitated rate than they would if they were in the free world, is a factor that can be considered by any sentencing authority, judge or jury.
All right, so if you'll remove slide number 14, you can ask whatever questions you want to ask about that, and if there are objections, the court will make a ruling on those objections.
Okay.
Number 15, I'm going to allow that. Uh, 16, objections.
Judge, I mean, I guess the objection is just, of relevancy and no relevance.
We have a fact witness who will testify after this that will make this relevant.
It's not relevant at least this time, Your Honor.
It's conditionally relevant. I mean,
Well, if you say it's conditionally relevant, but if you don't have the person to testify, then
I mean, all I can say is that, as I've stated in opening, and as I anticipate the evidence will show when we call a fact witness, this slide will become relevant. And that's my representation to the court. Obviously, if for whatever reason my evidence does not end up supporting that, the court is welcome to instruct the jury to disregard the testimony about multi-generational factors.
okay, so with regards to slide number 16, that will be allowed. 17, 18, 19, those will be removed. You'll just need to testify.
Okay.
Number 20 and 21, what are there objections?
20 and 21, Your Honor?
Yes, I'm asking the state if they have any objections.
Judge, no, I mean, as long as it's not testimony about this particular defendant and just in general.
All right, Dr. Fabian, 20 and 21, is that general? I'm sure is it general, and then you're going to make it relevant to Mr. McIntyre?
I mean, that was the plan, yeah.
All right, so 20 and 21 can remain. All right, then let's look at 22, 23, 24, and 25. Those all seem to be the same as far as to what they're about.
And, Your Honor, I need to take care of the matter with the witness. If Mr. Lang can fill in for
Sure.
the rest of this hearing.
Yes.
Your Honor.
Sir, sorry, Judge, where did we leave off?
Oh,
Never mind. So with regards to, the court will allow the slides in up to number 25. Number 26, that seems that that's more testimony. So 26, if you can remove that and you'll just have to testify.
Which one is that one? Because I did remove them. I'm not. Which one is
26 is do insecure adult attachment styles mediate the relationship between childhood maltreatment and violent behavior.
that? Okay.
All right, meta-analysis of attachments to parents in delinquency.
I'm sorry, Judge, was there an objection to 20, is it 26?
Yes, 26 is, he will need to remove that slide, but he can testify.
Okay.
And then 27, the court is going to allow that. Uh, 28 will be allowed. 29. Any objections?
he was saying relevancy, Your Honor.
And we would offer it as a learned treatise, Judge. as an
All right,
exception.
29 will be allowed. 30, that will be removed. He'll just need to testify to that. And 30 is the brain development and trauma.
Yeah.
31, that will be allowed. 32 is allowed. 33 will need to be removed. You can testify.
Okay.
34, removed. You can testify. 35, removed. You can testify. 36, removed. You can testify.
And Judge, I'm sorry, I haven't, is the state objecting to these?
They're objecting to all the slides.
You're objecting to
Yes,
just
yes.
whole cloth to everything as hearsay, or what?
Correct, yes. Hearsay, relevancy.
Yes.
Okay. I would object to their objection. I hope the court would take note of that. I don't believe that any of these slides that you removed from 30 to 36 would be inadmissible for any reason.
All right. So 36 will be removed, but you can give your testimony about it. And some of the reasons why, with regards to that slide, so the record is clear, this is just going to be his testimony. It's not necessarily demonstrative as it relates to that. That's testimony. 37, that will be allowed.
Which one is that one? Sorry.
37 is brain development and delinquency. And I'm allowing that because that's from a treatise, even though necessarily that's something that you could testify to, but I'll allow it.
I'm sorry, Your Honor. What does it start with? Like
Empirical research
yeah,
supports.
research?
Yes.
Got it.
38 will be allowed. $39 and $40 allowed. 41, you'll just have to testify.
Okay.
So if you remove 41. 42 will be allowed. 43 is allowed. 44 needs to be removed.
Okay.
And let me know when you are ready to proceed. And is anyone going to need to take this witness, warning this witness for his level of expertise?
No, we know. Dr.
Yes, I think everybody does.
We understand that he's an expert in this.
All right, let's bring the jurors in.
Yes, Judge.
have some leaves that aftertaste in my mouth. It's almost metallic. Getting a piece of.
And Your Honor, I just want to make sure I understand. I think, if I understand the court's ruling correctly, you've asked to remove these slides because they are reflective of his testimony, but you haven't made any preliminary rulings about the substance of the testimony. I'm allowed to
No.
ask those questions.
Yes, you are allowed to ask those questions.
Thank you, Judge.
And so the court is clear. The slides were removed because the specific slides that the court ruled to be removed were removed because they're testimony and not demonstrative. The defense is allowed to ask the witness questions about those slides that were removed, but they're not demonstrative.
I
All right,
understand.
let's bring the jurors in.
All right, for the jury.
All right, everyone, please be seated. All right, defense, call your witness.
Defense calls Dr. John Fabian.
All right, ladies and gentlemen, Dr. Fabian has been previously sworn in, so he's under oath. He's appearing by Zoom because he was unable to appear in court. So both parties have agreed that they have no objection to Mr. Fabian appearing by Zoom. Is that correct, State?
That is correct, Your Honor.
Defense, is that correct?
Yes, Your Honor.
All right, Dr. Fabian, if you can state your name for the record, please, and spell your last name.
Yes, John Matthew Fabian, Fabian.
All right, defense, you may proceed.
Thank you, Your Honor. Good afternoon, Dr. Fabian.
Good afternoon.
If you could briefly just tell the jury what you do for work.
I work as a forensic psychologist and a neuropsychologist.
And in addition to those fields, is there any other field that you have credentials or training in?
It's essentially clinical and forensic psychology and neuropsychology and law as well.
Okay, and in terms of the word forensic, that means that you're dealing with courtrooms a lot?
Yes, just addressing, answering legal, forensic and mental health legal questions that courts, judges, lawyers have that I can address through evaluation, typically.
How long have you been testifying about matters of forensic psychology?
About 26 years.
Have you published anything in this particular field?
I have. I've published quite a bit. It basically in areas that I work in, such as, not guilty by reason of insanity, competency to stand trial, forensic assessment of violence, let's say, and basically neuroscience and violence or sexual violence. So basically publishing in areas that I practice in.
Now, you're obviously appearing to us through a television screen. If you could please explain what exactly it is that keeps you from being in court with us today.
Oh, it's another never-ending death penalty case in Harris County, Houston, Texas. So I've been here for this is the second week of just part of the trial. So that's what I've been doing.
In terms of this case, are you familiar with Mr. Taymor McIntyre?
I am, yes.
And were you asked to do a forensic consultation with regard to Mr. McIntyre and his case?
I was, yes.
If you could please discuss for me the things that you reviewed in order to prepare for this case.
Sure. So your team had provided me with some information just about his background history. So there's Tarrant County juvenile probation records that I had reviewed. I had also reviewed some police reports, I think, for him and family members. And there was, I believe, psychological evaluation from Tarrant County as well when he was a juvenile.
Okay, you mentioned family. Who did you speak with respect to Mr. McIntyre's family?
So I interviewed Mother Jolena, Sister Kayla, Father Kevin, and paternal grandfather Russell.
Did you look into anything related to his academics or his intelligence or matters pertaining to that?
Yes, I had interviewed your client as well, or examined him on April 2nd and April 3rd, 2025. So I also obtained information about his background history from him.
Okay. Is that common to do, to get that kind of information self-reported from the patient or from the defendant?
Absolutely, yes.
Did you review anything with regard to Mr. McIntyre's mental health?
Yes, I did. That was primarily from the psychological report that was done for his initial juvenile case in Fort Worth and Tarrant County. And so he had been evaluated there by a psychologist. And that was, I think, in about 2016. And actually, I think the date of evaluation was November 15, 2016. This one was actually by Bear County psychologist Monica Jeter, and that provided me information. He had a history of attention deficit hyperactivity disorder and treatment with Adderall for that condition.
Okay. So I want to talk a little bit about matters related to the psychology of an offender that are significant, both in this case and in cases generally. When you're trying to evaluate these matters to determine or to help talk to people who are determining a sentence, what are some of the things that you look for?
Well, I look a lot at their background history and their family history. It's kind of where I start every case.
Okay. With respect to Mr. McIntyre, were there any risk factors that you would... I'm sorry.
The information gathering, sorry.
Just one moment. So if y'all can make sure one person talks at a time. So defense, if you will ask your question, please.
I'm sorry, Your Honor. I think we might have had a buffering problem.
Yes.
I thought he was finished talking. Dr. Fabian, with respect to Mr. McIntyre, were there any aspects of Mr. McIntyre's history, whether it be mental health, family history, background and upbringing, that you were looking at to determine whether or not there were pre-existing risk factors before these cases came to light?
Yes, there were a number of areas pertinent to your question.
Could you?
So you may explain.
Yes, please.
Okay. I look at this as multi-generational in nature. So I did talk to his mother. And if I may briefly describe her background.
Please.
Okay. She had informed me that she
Your Honor,
was...
I'm just going to object to hearsay.
Sustained.
And Your Honor, just for the purpose of the record, we would be offering it as a statement that was obtained for the purpose of medical diagnosis.
For the purpose of this trial, Your Honor.
Sustained.
Without going into what she specifically said, Dr. Fabian, are there some aspects about the people in Mr. McIntyre's life, his parents, that you thought were significant and relevant to what was going on in Mr. McIntyre's development?
Yes, there was a family history positive for criminality, substance abuse, mental illness, and prostitution. And those are factors that I thought were significant, for his parents and then when he was born. So that's kind of where I would start in my investigation.
Okay, and just before we go any deeper into that, can you explain a little bit what you mean by multi-generational trauma? What does that look like?
Well, it looks like the parents of the defendant had a lot of adversity and trauma in their lives growing up, and when he was born, after he was born, there was family separation and instability. And, that's not uncommon with what I know about his parents' background history.
Okay, and when those kinds of circumstances are in play, what effects can that have?
That could lead to what we call developmental psychopathology in offspring. And that could be, psychiatric conditions that would be relevant to, Taymor and his siblings, let's say. It's my understanding that there was, maternal substance use during pregnancy with him, and he had early emotional behavioral difficulties, and then later depression, suicidality, and his own substance abuse problems.
What is polytrauma?
Polytrauma is just when someone has a number of different types of traumatic events that they've either been exposed to or witnessed.
So, like, for example, psychological and physical abuse, that would be a polytrauma case? Or is that
Yes.
what you mean? Okay.
Yes.
What is,
So there.
go ahead. Sorry, doctor.
Well, I don't know if you want me to elaborate as to his history of that.
Please.
Sure. He and his sister Kayla had bounced around quite a bit. So they had lived with mom, and eventually they were, I think, in a hotel in Las Vegas, and she had been involved with crystal methamphetamine, and social services got involved, the police got involved, and they were taken, and they were placed in Child Haven, which is a orphanage setting, and they were then moved to different foster homes. And so there was abuse and I would say more emotional neglect within the foster home than one particular placement. And then they had also witnessed significant domestic violence by father to mother, I believe even before that. And father had gone to prison for that assault against mother. So eventually they were placed with their grandfather, and that was the most stability I think they had. That was a paternal grandfather named Russell, and he had them for about 4 years, and I think they thrived at that point. And then once father was taken out of or was released from prison, he reached out and wanted the children. So they went back with father. And I think this is more in the Arlington, Texas area. And father and stepmother were raising Taymor and his sister Kayla for a while. I learned that there was abuse in that home, and they started running away, especially Taymor.
Can you tell the jury about what damaged attachment is?
Damage attachment is really, the attachment processes is critical to, child development. So it's really the connection, physical, emotional connection between child and caregivers. And then really it serves as a lens to how, child views the world and how they develop emotionally, kind of how they think, perceive, the world, and how they develop, and how they socialize. And in this case, it was very, I would say, damaged because there was really a lack of stability and continuity and with the caretaking, because it was just, they bounced around a lot to different states and caregivers.
So,
and they were involved in the system.
So the more people that sort of fill that role as caregiver in an inconsistent and ad hoc way, does that have adverse effects on how children come to understand the world and how they relate to people?
Perfectly said, yes.
So in this case, you're evaluating questions related to, which I think you call neurodevelopmental disorder, right?
Yeah. Mm-hmm.
And then you mentioned also that there's the brain dysfunction issues. Is that the ADHD component that you discussed?
That, and it can be how the brain develops in a basically a traumatic environment. So those two issues of neurodevelopmental disorder, which would be ADHD as an example of one, but also just growing up with abuse and neglect can also affect, how the brain develops as well. I can, kind of show some slides if you wish, but on a PowerPoint, but basically that is relevant to the case here. Because, we have to remember he was, I think, only 16 when I think this offense occurred.
You mentioned that you prepared some slides to discuss some of the topics that you're here to discuss with the jury today.
Yeah, I did.
Would you mind sharing that with us?
Yeah, sure. Let me pull those up. I'm going to share my screen, Your Honor,
All right.
and probably take over the screen here. Can you see what I got?
Yes.
Okay. So we covered some of this. Well, I don't need to talk about myself, but let me, we may want to go back, counselor, but we're talking about attachment here.
Right.
Okay, and this is basically what I mentioned before. And then if we're going to talk about the brain, first of all, just with development, it's relevant to self-identity, sense of self with others in the world, and really emotional regulation and social development, okay? So the concerns I have in this case, and a lot of cases I do when there's damage attachment, is that there's going to be a risk for, like I said, we call it developmental psychopathology, but often that basically means mental health issues or conditions developmentally from childhood through adulthood.
So that slide there says the phrase insecure and disorganized attachment.
Yes. So, there's been studies just in juvenile delinquency, and they've, examined delinquents and found that they are at risk for two types of attachment conditions with caregivers, and one's insecure and one's disorganized. And in essence, they found that there is a correlation between attachment, and I will just call it damage attachment for brevity, and juvenile delinquency.
Now, are you familiar with these types of orphanages that serve as both the housing for the children that are in their care, as well as where they go to school, where they do their extracurriculars, so it's all on one campus?
Yeah, I used to work at one of those during my master's degree, and they're very similar, and they have, unfortunately, everyone is kind of in the same pot, so to speak. They all come from, broken homes with a lot of these kind of negative consequences, mental health issues, addiction, criminality, and so they're placed all together.
So that kind of an orphanage that has some similarities to juvenile detention or to adult jails?
Yes, and oftentimes they don't have the deterrence in the orphanage because they're often not locked. Okay, so the kids can often run wild and cause problems
within the facility.
Correct, and then in this case, Taymor was fostered out, I think, to, it's my understanding, at least a couple foster families. One that was more consistent, it was about 2 years with a woman, and there was some concerns about abuse and neglect in that foster placement.
Okay, which would go back to this problem about improper or inadequate attachment based upon multiple caregivers, multiple situations.
Yeah, I mean, within the family and outside the family. So there was just a lot of inconsistency, instability, and, that is obviously going to place a youth at risk to have some developmental issues.
Now, I did want to go back for a moment, Doctor. You had mentioned we might need to. Are you familiar with the Office of Juvenile Justice and Delinquency Prevention?
Yes, I am.
And I gather that they've published some work on trying to assess these risk factors and how they may contribute to later life delinquency.
Yes, they have.
Could you talk to us a bit about that?
Sure. So, the Department of Justice has done research on just risk factors of juvenile delinquency, violence, and I would say even young adult violence. And they basically just found different domains that make sense, just individual risk factors inherent pursuant to that person's psychological, psychiatric functioning and mental health makeup, so to speak. Family factors have a lot to do with just the structure of the family, who's there, is it broken, who's raising the children, but also family management practices, including discipline, supervision, and then school, peers, and the community. So there, when we're looking at these cases, there is a cumulative type response or outcome. So the more domains and risk factors, the more likely the youth will have difficulties in life and engage in delinquent and violent behavior. So in this case, there are certain factors relevant. I can briefly go through them if you wish.
Please.
This defendant, Taymor, had evidence of hyperactivity. He was not of low intelligence, but he did have a significant ADHD condition and treatment. There were emotional factors. It's my understanding that he struggled without having his parents around, and eventually there was again some neglect where I think mom had left the children just abandoned in a hotel in Las Vegas, and that's when CPS got involved. Later on, there was more stability with grandfather, but then not so much with father. There's more abuse, and that's when he was running away and engaging in more antisocial delinquent behavior, which connects to more of the peer factors. He was associated with delinquent peers, and it's my understanding that both he and his sister, and what more, Taymor was running away from the fathers due to the abuse. And it was difficult, I think, for him to consistently attach to schools and his academics and success in that area because of a lot of the moves, neighborhood changes, let's say. So that's kind of how I conceptualize this case within the Department of Justice kind of risk factor domain, so to speak.
So within this concept of risk factors contributing to delinquency, is there any kind of a buffer that one can have when confronted with so many of these circumstantial risk factors?
Yeah, that's a good question. And the thing, what I consistently learned was that I think their most healthy and stable placement was some of that protection by the grandfather figure, Russell, but also he got them to counseling. They were more involved in organized activities, and those 4 years, I think, were stable, and there was less, I think, acting out. There was more structure, there were more expectations, and so it was protected not only by the caregiver, the grandfather, but also the opportunities he gave them.
So do these risk factors that we've discussed have any role in trying to predict the risk that someone might commit homicide?
They do, and so when we're looking at delinquency, but then so there has been some research on this.
Could you tell us about it?
Yeah. Where they were looking at, the researchers were looking at a youth study with basically delinquents and looking at early risk factors in childhood and adolescence and as predictive of violence. And so they basically found a collection of them which are relevant in this case. So as I'm looking here, you can see my arrow. I think they're all present here. And this was into, I think, homicide through age 30. So there were several factors of 28 that really kind of were more powerful. And another, again, this is correlation research. They found these are really significant to this youth group, and it's a pretty good sample size of over 1,500 kids. So as being risk factors related to homicidal behavior. And so that would be, I think pertinent to this case and Taymor's background history.
So when you talk about those factors, you're talking about where the study looked at physical abuse, parental stress, bad friends, low school motivation?
Yes, that would be correct. And it's my understanding these factors would apply in this case.
So fair to say, if your home life is tumultuous, if your peers in school are of bad company, and you have little hope or prospect for being able to succeed or carry forward with what you want to do with life, the risk that this kind of a thing happens goes up from a correlative way of speaking.
Objection.
That is correct.
Objection.
Sorry, just one moment. What's your objection?
Objection, Dean.
Sustained.
I'll withdraw. Dr. Fabian, when these factors are present, what does that actually mean in terms of the risk?
Well, they're just elevated. So, in this particular study, it looked at homicide in particular. But as far as we looked at the DOJ factors that I went over, those would be for delinquency. Now, these several factors focused on homicide.
What are the ACEs?
The ACEs are average childhood experiences risk factors, and in brief, the CDC and Kaiser Permanente, they basically did physicals, examinations, and asked thousands of individuals about just childhood traumatic experiences. And they found that there were about 10 risk factors relevant to, they were in childhood regarding traumatic experiences that were correlated with a risk of negative, what I call like psychosocial outcomes. So it could be addiction, mental health, medical problems, addiction, legal problems, early mortality, let's say. And there were about 10 factors they found.
What are those 10 factors?
Well, they focused on abuse and neglect. So physical abuse, emotional neglect, sexual abuse, parental separation and divorce, living with a person in the home that had addiction or mental health problems or legal problems and incarceration. And so there were 10 of them, and they found that 4 or more, basically a cumulative effect, but 4 or more out of 10 placed, the individuals in the study at more serious risk for like negative psychosocial outcome. And it could be anything or a combination of outcome. It could be, again, like unemployment, addiction, divorce, early death, for example, okay? And I did run analysis on your client, Mr. McIntyre, so.
What did that analysis reveal?
Well, revealed that he had 8 of the 10. So, pretty high score. and again, indicative of just abuse, neglect, and adverse child experiences.
So what you're saying is we can't really predict what negative outcomes someone will experience if they have these things, right?
You are correct. Now, there are some studies that are kind of focusing a bit more, on these factors and outcome.
But
Which, yeah, go ahead.
each of these things could be potentially provoked by having 4 or more of these factors.
Yes, which, like these 2 studies, I think, address that. So just even with delinquents, they're more likely, or, with youth, they're more likely to engage in delinquency, in these negative outcomes, violence, gang involvements, addiction, general offending, when they have more of these risk factors. And this data pretty much, correlates with some of the DOJ data that we had just went over. It's just early risk factors, yeah.
Okay, so fair to say the ACEs and complex trauma have some relationship?
They do. Now, complex trauma is a serious type of trauma, typically occurs in childhood and within the primary caregiver system, so often abuse, neglect by a caregiver to the child. And they're often, the abuse, neglect occurs for a period of time, so it's a bit chronic, and then it can be intense, severe in nature, and it also can be frequent. And, again, we're looking at often physical abuse or neglect, sometimes, sexual abuse as well. And then this complex trauma really, it's grips in early childhood just for negative outcome, and when we see this complex trauma, is often integrated with that damage attachment because it's often from the primary caregiver. And in this slide, there's just a lot of effects of complex trauma on one's development in a number of areas.
Can you talk about different ways that kind of trauma might impair or impact a child?
Yeah, sure. So, as we see that there's attachment, deficits, just interpersonal difficulties, could be, distrust, suspiciousness, also problems with just interpersonally, and also with developing best ways to, I would say, with empathy or perspective taking. There's also affective regulation, emotional regulation, and I know that Taymor had difficulties in that area, and he struggled with needing attention, support, affirmation from caregivers that were not in his life, or when they were in his life, very needy, and he was needy within the school with teachers, for example. So self-regulation, emotional regulation, but also behavioral control is relevant here. He has demonstrated difficulties with, self-control, destructive behavior, aggression, violence we've seen, and addiction. And he's qualified for substance use disorders when he was in the community. And as far as thinking, cognition, I would look, there seem to be problems with attention, concentration, relevant to, separately to his ADHD condition, but also difficulties with just appreciating responsibility. It's difficult when a kid's growing up like this to also develop emotionally and in a mature way, like peers his age in healthier environments. I think that there was also like his self-concept, I mean, certainly, some of his vocational pursuits and, his musical talents, but, are impressive, but I think they cover a sense of inadequacy and a desire to be just connected with, like, his parents, which did not happen in consistent ways.
Are you suggesting creativity is some sort of a coping mechanism for a lack of a stable household and early childhood trauma?
Well, some people are talented and some aren't. So yeah, I think he has some gifted and talented in that way. But he developed other interests and skill sets, and there's some resilience there. But that I think he's plagued by inadequacy, especially with his just neglect for the most part by his parents.
The literature you've been talking about seems to also discuss how these experiences, the emotional experience, can have effect on the physical brain. Is that right?
Yes, that is what we've learned. Yes. Now, this slide, impact of childhood trauma, in part is related to the prior slide. And we see in this case, and just by my review of the records, I mean, there's been, he's had some issues in a number of these areas. And I would look at more emotions, I think relationships here, mental health. I have seen, I think he has a long-term depressive condition, evidence of post-traumatic stress disorder. He's been suicidal in the past, and he's developed addictions to substances. I would say cannabis, Xanax, and more of what we call lean or cough syrup, let's say. And then certainly he's had issues in this area, which is the substance abuse, regulation, aggression, is criminal activity.
Can we talk a little bit about adolescent brain development?
Sure.
When does the brain stop physically developing, or does it?
Well, the brain, I would say the most important part of the brain would be developing, I'd say by age 24. And I'll show that here. Our brain develops bottom up from brainstem to kind of, survival, breathing, heart rate, through arousal, emotional reactivity. This limbic area is really the area of the brain that is responsible for emotions. And this area is more developed in a child, where finally this develops, I would say, 23, 24. And that's more of your executive functioning, higher order area of the brain, abstract thought, problem solving, planning, executive functioning, decision making. That's more of the brakes on the brain, and the brakes to kind of assist in controlling impulses. It's another way to look at it. This is your frontal lobe. This is last to develop. This is your brainstem, first to develop. Your brain kind of develops it this way. This is more the primitive brain, and that's the brainstem, right? So survival, breathing, sleep. The limbic area, that's kind of, again, more related to your emotions. And the amygdala is like your watchdog, your alarm. And that is more of the emotions and fear center of the brain, and as well as memory formation, where memories are. Finally, right here, that's more of the brakes in the brain, breaking this area, and that's more like a reasoning, problem-solving, planning. So this is last to develop, and certainly this area of the brain is developing still at age 16 when all this was going on with Taymor and his delinquency. That's in part why, adolescents are treated differently, within the court system. So this is the last area of the brain to develop, the prefrontal cortex.
So the parts of your brain that appreciate and react to fear develop before your brakes and your ability to judge and discern decisions. Is that what you're saying?
Yeah, and not saying that you have no ability to do that, okay? And not saying that every, adolescent becomes a delinquent, but, the area of the brain that is still developing, yes, would be kind of the control area on the emotions. And in a case like this, there's a bit more, let's say, could be delayed development, but there's other factors going on in this
And
type of
excuse me,
case.
doctor, just one moment,
Sure.
because I noticed some movement in the seat. Yes, I'm going to give you all a break. Do y'all need a break? I thought someone did a break sign. All right, so I'm going to give you all a short break. If I could have you all back by 2:40, is that enough time for everyone? All right, remember my previous instructions. Everyone please rise for the jurors. All right, everyone please be seated, and Cindy, we're off the record. So just so everybody knows, when I hear a lot of movement in the chairs, that usually means that they need a break. So we'll be back at 2:40, and Dr. Fabian is taking his break as well. So 2:40, all right. please be seated. And Dr. Fabian, you're still under oath. You may proceed.
Thank you, Your Honor. Doctor, I think when we're on the break, you were just discussing to the jury about adolescent brain development and the order in which the brain sorts of develops. But I guess, do I understand the gist of what you're saying to be that a 16-year-old's brain has not fully developed?
That is true, yes. So the adolescent brain is more geared towards the limbic area, the emotional area of the brain. The prefrontal cortex is still developing here. We just call that more of the brakes on the brain related to executive functioning, problem solving, planning, decision making. So then that brakes on the brain and a lack of self-control, lack of full brain development is going to be pertinent to delinquency.
And that would be the case generally whether someone has had a traumatic childhood or not.
Yeah, that is correct. Yes.
So what happens when we combine the multi-factor traumatic experiences you've discussed here today with finding someone at that moment in time of having an adolescent brain?
So when we're looking at human behavior and delinquency, violence, it's multifaceted. So it has to do with, developing brain, impulse control issues, frontal lobe is not fully developed. However, there are other factors involved in a case like this, and that's just really, that gets back to some of the early childhood risk factors we looked at. There's also like criminality in the home, substance abuse, just a lack of stability. And eventually around this time, it's my understanding he was running away from home because his father, there was abuse in the home. And so then that's when he was developing, more of these connections with other similar age peers. And that was when he was becoming more delinquent and getting into serious trouble regarding these cases at age 16.
Yeah, a lot of what you've talked about seems to be about early childhood and, when a child's, say, maybe 10 years old. What happens when there's abuse and trauma in someone who's 15 or 16 years old?
Well, it's more of the same, and at different times of his life, it's hard for me to always know exactly where he was living with who, and that really goes to this instability in his life. And so there was just different caregivers, different cities, and it gets you a little dizzy trying to know exactly where he's living and with who he's living with. So there was physical and emotional abuse going on around that age 15 by father, and unfortunately he was not living at that time with his grandfather, which again, that home provided more stability and structure, and so the process of trauma, abuse, neglect certainly can be developmental even through adolescence.
Now, Doctor, I want to shift gears for a moment. I want to ask you, are you familiar with the psychological and pharmacological effects of the drug LSD?
Somewhat. I know what type of drug it is, and I think I'll stop sharing here. Okay.
Can you tell the jury a little bit about that drug and what it does to the human brain, to the human body?
Okay. Basically, the drug is a hallucinogen, and it can make the individual psychotic, to lead to hallucinations, and it can lead to delusions as well, paranoia, and it also can affect the area of the brain where, more of the striatal area of the brain, where there's just different emotional processing, I'd say.
Can it have lingering effects after the acute intoxication has subsided?
It can. That depends a bit more on how frequent the drug was used. That would be my first answer. When did this individual start using the drug, and how frequently, how much in quantity, and did they experience, what did they experience as far as side effects of that drug in the past?
Okay. I also want to talk to you a little bit about a different subject. You also mentioned that you have some training as an attorney, is that right?
I don't practice as a lawyer. I have fellowship training in forensic psychiatry in the law and went to law school. So I know a bit about the law, but I'm not going to say I'm doing your job.
I want to talk a little bit about, the concept of the emotion of anger generally. With respect to anger, is it fair to say anger is a normal human emotion?
Of course, yeah.
And when we talk about things that provoke anger, are there aspects of life that you would expect anger to be the natural, ordinary response?
Yeah, I would agree. Certainly we're all different. But yes, we all perceive our emotions and handle anger and react differently.
So, is that something that you look for in people who are having difficulty with their mental health and with processing human emotion in terms of how they respond to something that might be an angering or exciting event?
Yes. And whether it's related to maybe their offense conduct, yes.
Okay. So when we're looking at that, let me ask you this. If we're talking about issues related to a sense of love or betrayal of love or resentment about a romantic engagement, things like that, is anger an emotional response that's common to see with people psychologically?
Yeah, I'm just going to object to one, leading, and also its relevance.
Sustained to leading.
When you have you dealt with people in your practice who have struggled with issues related to, failed romance or infidelity or jealousy about someone?
Objection, leading.
I'll allow him to answer that question. You can answer the question.
Yes.
What are some common emotional responses you see in those types of people?
I'm just going to object to relevance of this question, Your Honor.
Relevance.
Well, Your Honor, it goes to questions related to the testimony in the guilt innocence phase of the trial. It goes to questions related to whether there was adequate
Testimony
hearing.
related approach.
familiar with the concept of adequate cause as it exists in the law regarding the question of sudden passion?
Yeah, I'm familiar with the term. I mean, I'm familiar with sudden passion as well, and I've testified to it on at least 1 or 2 occasions.
And when assessing that, what are things that you are asked to examine and consider?
Well, what let's say the alleged victim or victim was doing prior to or during this offense, for example.
So are you looking at things related to the normal emotional responses of people who do not have some kind of a mental health problem? And how a normal person would react under similar circumstances?
Well, that would be, you mean with the defendant?
Right.
Yes. Yeah, typically, I think under the Texas statute is more, the typical or normal person, how they may react.
Okay, and do you think that your training and experience in these fields of forensic psychology would be of benefit in understanding how people react emotionally to situations that may give rise to a discussion about sudden passion?
Yeah, I've done that before. Certainly, it's more of a legal question. If the judge decides I can testify to it.
So,
Yeah, I was object to a legal conclusion. That's
Sustained.
Your Honor, we would just submit that we've laid the foundation, requested we'd ask a ruling on
He's
this.
not, the objection is sustained, he's not allowed to make legal conclusions.
Without going into a legal conclusion yourself, Doctor, what I'm asking is, are you familiar with the types of emotional responses that we would be looking to see in a normal person when questions related to sudden passion come up?
Yes.
Would that be one way of considering that question? Not the only way, but is that one way of considering it?
I would agree with that.
So, with respect to that, if we have evidence suggesting that there was some sort of a conflict about romance or jealousy about a significant other, what are the types of things that you as a forensic psychiatrist would want to know about that event or that incident to assess how a normal person would react?
Well, certainly what the disagreement was, the history of relationships between the parties, any prior aggressive conduct or problematic situations between the parties, for example.
Okay. And if you had evidence, hypothetically, that an individual was trying to have sex with another person's girlfriend, would that be the sort of thing that you'd want to look into more to determine how a normal person would react to that information?
Sure, and definitely. I mean, I guess relationship, jealousy, that type of thing, yeah.
Okay. Is that something that has come up in instances where you've been asked to assess whether a normal person reacting in anger was acting appropriately?
Yes.
Your Honor, I think with that predicate we would reoffer and ask for his opinion about the hypothetical in more detail. I just don't want to run afoul of this issue.
All right, if everybody can approach, please. Finch can proceed.
Thank you, Your Honor. When we talk about emotions like anger, rage, resentment, or terror, can you describe sort of what's going on in the human brain when someone is under the experience of one of those emotions in a heightened form?
Sure. I mean, basically, it would be more related to different brain regions, more in the area of I'd say the amygdala, which is again more that fear factor center of the brain, and even prefrontal cortex, and some of that anger can be related to.
We're frozen.
Kind of fight, flight to fear. So there can be.
You froze a little bit, so if you could start over with your answer, please.
Sure. Sorry about that. Anger involves just a number of areas of the brain, so it's multifaceted, and it would be in much part related to the amygdala, the emotional area of the brain, and that's again your kind of fear center of the brain, more the watchdog, your alarm switch. So that is one area of the brain, and that also processes threat, frustration, and is connected also with processing within the prefrontal cortex, which is again more of that brakes on the brain. So there's critical circuits between those two areas of the brain that are responsible for feeling the threat, perceiving it, and then reacting to it.
When we talk about brain development, going through childhood, adolescence, into adulthood, when you talk about the breaks that you mentioned earlier that are achieved later in your 20s, does that have any role to play in how an adolescent might modulate their anger?
Yes, it does. Can I share my screen, Your Honor, real quick again?
Yes.
Thank you. So basically, you can see this right here. This slide has to do kind of with adolescent brain development, and right here, this is part of the frontal lobe, and they call it pruning. Basically, it's kind of like a shrub, and you got to reshape it, and some of the gray matter is pruned, and this happens in adolescence and early adulthood, and basically, while your brain's developing, it's this frontal lobe area is pruning, and it is critical for more of the brakes on the brain. So the controls, the judgment, decision making, and so that's how I would answer that question.
So in a 40-year-old man, they get angry about something. They may decide to bite their tongue, not say anything, internalize it, try to get over it without any behavioral component that the rest of the world can see. Do adolescents struggle with those kinds of skills?
Yes, they do. I mean, some more than others. In this case, I would say that given his ADHD brain, which is more impulsive, hyperactive, and given how he was raised and more of that trauma and symptoms of PTSD, emotional reactivity, he would have potentially more difficulties with that in times of stress, and he's more, I'd say, at risk to even misperceived threat due to his history of trauma.
Now, and just for the sake of a hypothetical, taking away those additional factors, a quote-unquote normal 16-year-old boy would have difficulty modulating their anger in relationship to, say, a 40-year-old man?
everyone is so uniquely different. When we're looking at brain development, that issue, yeah, they may have more difficulties. But again, some folks are more resilient than others. But if it's we would say based on the research, especially in those areas of the brain that are developing, we could agree that that's an accurate statement.
And when I say modulating your anger or putting the brakes on, as you talked about, when there aren't brakes or the brakes aren't applied or you can't modulate an emotion like that, what happens with that emotion? How does it run its course?
Well, if you have difficulties, let's say your prefrontal cortex is not fully developed, one could have compromise or be more risk to have difficulties with controlling emotions, let's say. So, the person's more likely to, I would say, react more in a dysfunctional way. They may act out, may have difficulties emotionally regulating and problem solving in that moment. And so there's a lot of factors involved, if I may. Fight, flight reactions based on your trauma history, your brain development. It's very complicated.
Is it fair to say that when one particular emotion is sort of running away in your mind, other emotional responses are subdued and less likely to, interject?
Objection leading,
Sustained.
How does a intense emotional response register in respect to the other types of thoughts and ideas a person might have in their head?
In part, that depends on their experience, okay? And in a case like this, I have more concerns that due to this abuse, neglect, especially physical abuse by father, Mr. McIntyre's, I think brain wiring and the emotional circuits connecting to the cognitive brakes circuits are going to be perhaps more compromised, in their development at that time. And so, I think a lot of it has to do with the past history of when he's been frustrated, in fear, in terror, angry. Okay, so that's how I look at how has he handled these situations in the past. I'm just saying that the risk factors that he has related to ADHD, brain development, and trauma, place him in jeopardy to handle his anger and stressful experiences perhaps more than the typical 16-year-old.
Thank you, Doctor. Pass the witness.
Senator. Yes, you may proceed.
Thank you. Dr. Fabian, thank you for being here today.
Sure.
Let me ask you just a few questions here, sir. With the review of the material in this case, can you just tell the jury what additional materials did you view? I mean, you said you reviewed police reports, is that correct?
Yes.
And then also some reports by other psychiatrists, is that correct?
Yes.
And then did you also review criminal history?
Yes.
And then also just some other maybe non-traditional factors. Did you also review, say, news articles?
Yes, actually, yeah.
And I'm assuming you mentioned that his music talent was impressive, so I'm assuming you reviewed some of his music.
Yeah. For a lot of people, I mean, I've heard a lot about it. It's not my genre of music, but.
And speaking of that genre of music,
May we approach you on?
Yes. Matter I need to take upside your presence. Remember my previous instructions, and I will have you come back in a few moments. So everyone, please rise for the jurors. All right, everyone, please be seated. So, the witness testified that he listened to some of your client's music. So, the state is allowed to question the witness about anything that he reviewed for his testimony. That's the first point. The second layer to this whole question, you filed a motion in limine. So I need to make a determination on specifically what music that the state is intending to offer through this witness that he said he listened to, and I'll make a decision on whether or not I'm finding that it's more prejudicial than probative. I don't know what the music is, haven't heard any music, so let me just see what the music is.
Your Honor, would you like me to, one, it'd be City Exhibit P5, which we are marked. We've loaded the disc into the disc player. And would you like us to play it now, or would you like any other questions that we have?
Well, let me ask this first. I know you're saying it's loaded in the disc player, but does anyone have just the transcription in words so I can see it?
It's in the motion in limine,
It's
Your
in the
Honor.
motion in limine that the defense presented to you, Judge, but I also have a copy.
Oh, if you could bring me a copy because files are...
Yeah, okay, so
They might object to the
well,
transcription.
I don't know the answer. Some versions of the song, these first four verses are in it, and other versions of the song, it's not.
I know that you repeated it at some point. Yeah, it's
Yeah, you're right. Okay. But Your Honor, before we get to that, the substance of it, I do think that we have to establish whether or not the state's question adequately puts this at issue. What we're doing here is...
Just one moment. Let me review this and then I'll hear everybody's arguments. All right, state who you are. All right, so state if you want to ask the witness questions, and let me see.
Okay, Judge. And Dr. Fabian, we were just previously speaking about Taymor McIntyre's music. Is that correct, sir?
Yeah, I agree.
And you stated that you reviewed it, obviously, and that some of the material that you reviewed was obviously very well known by individuals out in public. Is that correct?
Correct.
And assuming you've listened to one of his more, I guess, highly listened to songs was The Race. Is that correct?
Correct.
And also there's an associated video with that song. Is that correct?
Yes.
And you've listened to it, and then you've also seen the video. Is that correct, sir?
Yeah, I didn't watch the whole thing, but I got a good glimpse of an idea of it.
And you saw on the video that Taymor McIntyre, this is back in 2016 when he was making this, right?
Right.
And he's walking around in that video with guns.
Yes.
And his rap song, and I'll just ask you some questions if you can remember. You listened to the full song, but do you remember some of the actual words of the song?
Yeah, I think it was about, I think, being in a race and beating his case or something like that.
So referring to a case that he's in a race away from, is that correct?
Your Honor, I'm going to object to the way we're proceeding here. We're running these leading questions through the witness. We should just ask the witness. What is it? Well, this isn't cross. This is a hearing outside the presence
You
of the
can
jury.
remain seated, counsel.
I think that the appropriate thing to do would be to have him disclose the underlying facts and data supporting his opinion under Rule 705. That's what we're here for. So that we can determine what the witness actually knows, not what Mr. Garahan knows. And then ask him
This
point blank.
witness has stated that he has viewed all of this documentation. This witness has been presented as an expert by the defense. The state is allowed to question this witness about items that he's reviewed, similar to if the state were to offer an expert witness, the defense would be able to ask them questions about things that they reviewed to form whatever opinion. What I'm telling both, and I want everyone to internalize what I'm saying. One, I am trying to see through this questioning, and you'll have a chance to question them as well. We're outside the presence of the jury to make a determination on one, whether or not, which I'm assuming it appears that the state is seeking to enter either a video or lyrics of this specific rap song. I'm trying to make a determination on whether or not, one, I should allow that. And the way I'll be able to determine that is by listening to these questions. Now, if people do not want to follow what I'm telling them, then what can also happen, which would not be appropriate, is the jury can come out here, the jury can listen to all of your questions, you can do your objections in front of the jury, and I will make my ruling. But I'm telling you all, this is the way it's going to be done, and this is the appropriate way to do it. So state, ask your questions. After they ask their questions, if there are some questions you want to ask, you're more than welcome to ask them. We're outside the presence of the jury. I don't know anything about your case. I don't know anything about this case. I know people assume that the judges know about these cases. I do not. So, the information that you all are presenting, I'm hearing it for the first time. Don't know your client's music. Never heard this song before. Just now am I seeing what the state has presented in the form of a transcript that I'm assuming is a transcript of this song. Don't know anything about the race. Don't know what the race is about. So state will ask their questions. We're outside the presence of the jury. You will get a chance to ask your questions. Everybody will lay the foundation they think they will have laid, and then I'll make a decision on whether it's admissible or not. So let's continue.
Your Honor, all I want to say is that I understand what the court is saying, and I understand that that's how this will proceed, and all I want to do is make sure that my objection has been articulated, because I've been
Everybody will
trying to
have a chance to articulate their objection. I don't know what your objection is going to be because I don't know what the state is offering. So if we will just, everyone, just proceed this way so I can figure out what the state is seeking from this witness. We're outside the presence of the jury. They don't know anything about this. So then, after the state asks their questions, you will get allowed to ask your questions, and then everybody will get allowed to make their objections. I will give both parties plenty of time to make their objections. Now, the way it seems that you want to proceed is you want them to ask a question, you want to make an objection. Ask a question, make an objection. Telling them they don't have the foundation. Fine, we can do that in front of the jury.
That is not how I'm asking to proceed. I just want to explain why I am objecting to the initial decision to conduct the hearing.
All right, well,
I can do that at the end.
We're conducting the hearing.
That why we're having the hearing is something I also want to object to.
Proceed.
Thank you, Judge. Dr. Fabian, sorry, I sort of lost my train of thought here. But speaking about this song and also the video, you said you viewed the video portions of it, and then you also listened to the entirety of the song. And I was going to ask you, I did ask you about generally what the song was about, and what you stated was that he was in a race to beat a case. Is that correct?
Yeah.
And then there's the lyrics in this song speak of different things like Smith & Wesson made my nine with some compassion. Do you remember that phrase?
Vaguely.
Okay. And then also things like another phrase, rob a nigga shoes, rob a nigga lace. Do you remember that?
No, I know the subject matter of the song. I mean, like the idea behind it.
Okay.
Like where he was absconding, violating pretrial, cut his ankle bracelet, and was on the run. I mean, I know more about that than the lyrics.
And during this song, you realized it was released right before he was caught.
Yes.
And so it would have been after the murder here in San Antonio and after the murder that happened in Tarrant County.
Correct.
So this song could be speaking of these cases that he's racing away from. Is that correct?
Calls for speculation.
All right. The court will note that this is an expert witness. All right, you can proceed. That's overruled.
I would agree with that comment.
In lieu of, since we don't have this on digital form, Your Honor, the state's position is I'll pass the witness at this time for this hearing.
So, yes.
Thank you, Your Honor. Dr. Fabian, did we send you either the music, the lyrics, or a video about the song, The Race, the defense?
There's a little connection issue. Can you repeat?
What did the defense provide you with anything related to the video, the music, or the lyrics of The Race?
No.
You're familiar with this case outside of what we've consulted with you because it's a high-profile case. Is that fair?
Yeah, I heard The Race a number of times and I checked it out.
So it's something you're aware of independent of the scope of what we've asked you to look into in this case. Is that right?
That is correct. And I didn't really talk to your client much about it, actually.
In terms of your opinion, I know on direct we discussed creativity as maybe a crutch for lack of proper attachment. You recall that testimony?
Yeah, sure. It's a skill set that he has.
But apart from the general fact that he's a creative person, did you do anything with the information that he had produced this song?
No, I did not.
Does it inform your opinion in any way, shape, or form? Let me ask it a different way. You understand that you're here to testify about delinquent and violent behavior at a punishment hearing in a criminal trial, right?
Correct.
And that for the purposes of this punishment hearing, the jury has already found Mr. McIntyre guilty of killing Mark Saldivar, right?
Yes.
So, is anything about this music, does anything about the music, one way or the other, inform the opinion you've given today about brain development, about generational trauma, about these dysfunctional forms of attachment?
No, not those factors, no.
Does it inform anything about your opinion regarding drug consumption? Or the substance abuse in this case?
Right, probably not at this point, no.
Does it inform anything about your opinion regarding adequate cause or sudden passion, as those subjects were discussed in your direct testimony?
No. I would say no.
So this is something you're aware of, again, because it's a famous case, right?
Yeah, in part.
Well, I mean, we didn't provide it to you, correct?
No, but in the course of my evaluation, I heard about it and I read about it, so.
And the prosecutor asked you about the fact that there's wide media coverage about this incident, correct?
Correct.
And so those are the sources that led you to discover this song.
Correct.
If you were unaware of this song, do you think your opinion would be any different?
No, from a mitigating standpoint, I mean, the factors we talked about, his psychiatric diagnoses would be the same.
Pass the witness.
Yes.
Yes, Your Honor. I believe you stated in the course of your evaluation, you became aware of the song and this song in particular and other songs and music of Mr. Taymor McIntyre. Is that correct?
Correct.
And so you're in the course of your evaluation, you listen to the song, you look up other, for that matter, you stated it earlier in testimony, you looked up other news reports and other avenues that maybe defense counsel didn't offer to you, but you, doing a thorough investigation, did that on your own.
Yeah, I would agree. I mean, if you Google this defendant, a lot of information comes up, and I typically do that.
So, well, yeah, I mean, I'm not saying it's wrong. I mean, actually, it's right. You're a doctor and you're trying to get a full scope of the individual you're evaluating. Is that correct?
Correct.
And so getting the full scope of this individual and watching some of his talented music that he is the artist of, I mean, one, you can see in the video, it's in a sense acceptance of his peers. There's other individuals in that video that are gathered around him. Is that correct?
I think there's some other people in the video, yeah.
And so it'd be fair to say, and what you testified earlier, that one of the factors, and some of the factors that you used, maybe not supplied by the defense, but you did an evaluation, and part of that evaluation had some of his music and his occupation, that he was a rapper. Is that correct?
Yeah, I mean, that's certainly what I learned.
All right. Well, pass the witness, Your Honor.
Briefly, Your Honor. Did anything about the song, its lyrics, or the video inform the opinion that you have given today in this case?
No, you would have the same diagnoses, that whether I listened to the song or not.
If we played the video for you and gave you the lyrics and went line by line through it, do you have any concern that it would alter your opinion in this case?
I I haven't really been asked about his offenses.
And in terms of what you were asked to evaluate, you didn't conduct much of did you conduct much of an inquiry into his offenses other than the reports and the basic information about the case that we provided?
No, I was aware of his charges and I was aware of some of the evidence against him. We did not talk much in detail about, his offense history. That some of that was just, I think, attorney instructions, and so I just didn't focus on that. I investigated more mitigating type circumstances.
Whether this crime was committed as a matter of a robbery, or this crime was committed as a matter of a rush to anger, or this crime was committed because it was a Tuesday, the circumstances of why the crime was committed in any way change or alter your conclusions about Mr. McIntyre, his brain development, and his psychological issues?
I would say no.
Pass the witness.
All right, so the only issue here is whether or not the song that the state wants to question this witness about is whether or not it's more prejudicial than probative. Otherwise, the state is allowed to question the witness about the song. So, does anyone wish to argue whether or not it's more prejudicial than probative? And if you want to argue that it's probative, what is it probative for? If you want to argue that it's more prejudicial than probative, you can make your arguments to the court.
Your Honor, our motion limine cites to a recent Court of Criminal Appeals decision in Hart v. State, that's 688 Southwest 3rd, 883, Texas Court of Criminal Appeals. In that case, the court was highly critical of the idea of the prosecution using song lyrics or music that glorifies criminal behavior as evidence. Now, obviously, perhaps a distinction can be made between its use in a guilt-innocence phase and its guilt and a punishment phase, but I don't think so, because the problem is that the state may have a different use for it in punishment than they would in guilt-innocence, but the implications that its use has are the exact same. They want to demonstrate that the defendant is someone who has glorified criminal behavior, who has himself implied that he is engaged in serious criminal acts.
So are you saying it's probative of nothing?
It's probative of nothing.
All right, state, what are you saying it's probative of?
It's probative of indicative that even the doctor just stated that it talks about running away from a case. And he even depicted on there that the cases were just previous in 2016, and this is just months after he committed the murder here in San Antonio, Judge. So he released it after that. Doctor testified to that. And so it's the words of the defendant himself stating he's racing away from a case that he can't beat, and also shooting the person in the face.
All right, so here's the court's next question. It appears that from case law that flight is probative and flight is relevant. So the next question for the court is whether or not what the state is seeking to offer it for, whether or not it's more prejudicial than probative. The court is going to find it's probative. Does anyone want to address the issue about the prejudiceness of it all?
Yes, Your Honor. It is vastly more prejudicial than it is probative. We, in opening statement for the punishment phase of this trial, told the jury that Mr. McIntyre cut off his ankle monitor while on bond for the crime in Tarrant County and came down here. We are not disputing that issue.
But opening statements are statements, they're not evidence.
Well, yes, I understand, but the state has introduced the judgment from the Tarrant County conviction, which was the case he's referring to in the song. There's evidence from the guilt-innocence phase of the trial that Mr. McIntyre was arrested in New Jersey.
So are you going to stipulate in signed form that he cut off his monitor and stipulate that he was in flight?
Your Honor, I think that question puts us in an inappropriate position.
No, I'm just asking, that's all.
Well, the problem is...
And let me explain for the record, the reason why I ask is because defense, you stated that you had already given that information to the jury by way of your opening statement for punishment. And the court stated that opening statements are not evidence. And it appears that you're asking that the court block the state for many reasons from going into this line of questioning, but one of them being that you've already told them this in your opening statements.
Well, Your Honor, I guess here's my problem. I understand what the court's saying, but a concession by counsel at the opening statement, and certainly a declaration as an officer of the court, there will be no argument in closing to the contrary of that or to rebut that question, combined with the fact that this is a subject matter that we do not believe is sufficiently probative to overcome the severe prejudicial effect that it has, are all reasons why the landscape should just be left as it presently sits, which is that it's not in dispute. There has been no attempt to hide from it. There has been an open acknowledgement by counsel to the jury that this occurred. The state has provided evidence in the form of a verified, certified judgment that the crime that I referenced in my opening statement did occur and that Mr. McIntyre was convicted of it. But then to ask that we have to make a decision about whether to tender a stipulation to that fact, which requires Mr. McIntyre's express consent in order to avoid the admission of something that we believe
No,
should not be
and let me
admitted.
just tell you, I'm not asking y'all to do anything to avoid anything. The only reason why I brought up the stipulation is because counsel, you stated that in opening statements, you had already informed this jury that your client removed his leg monitor. And my response was, and I think correctly, opening statements are not evidence. It's just what people expect the evidence to show. So for this part of the hearing, for this punishment part, there's been no evidence submitted that he cut off his monitor.
I expected the state to put on evidence from people with firsthand personal knowledge of it to establish that fact. That's why I made that remark in my opening statement. I certainly did not expect that we would make an attempt to backdoor the information through Dr. Fabian and through a popular music song, instead of the state calling a live witness that would be subject to confrontation and so forth. Because there are a lot of circumstances that surround this question. So I think that that's the problem we're in, is that we're doing something with Rule 705 that it was never designed to do for a purpose that is already not in dispute by the parties, and that the state had ample opportunity to produce that evidence of, and we would have had no right to object to that direct evidence. It is, of course, the subject matter is relevant, but we do have a right to object to the song in lieu of that. It is an artistic work. There will be no evidence, and the state cannot produce anything other than a naked insinuation that what Mr. McIntyre wrote in this song is the truth. The fact that there are references to things that the state will claim are relevant is beside the point. There are plenty of songs people think are about them that are not about them, no matter how much they think that the lyrics match their own factual circumstances. And people oftentimes fictionalize what they write in their music from some kernel of true experience. There's no way for us to gauge that one way or the other, except if Mr. McIntyre wishes to take the stand and explain his lyrics to the jury, which he shouldn't have to do because of his Fifth Amendment privilege. So overarchingly, there is a lot to be lost by admitting this song in terms of a fair trial for Mr. McIntyre, in terms of the prejudicial effect it will cause on the jury's imagination. There's nothing to be meaningfully gained. It's not a matter in contested dispute. There is no danger that the state will have to deal with me saying the opposite in closing statement. And this witness is not the right witness to get this information from. It's not part of the underlying facts and data that form his opinion. It's not something that can ever be reasonably asked to inform his opinion. I mean, the fact that this is just something that is a part of this person's musical body of artistic work doesn't say anything about his mental condition, about his life prior to the events that gave rise to this case, nothing.
All right, okay, all right, thank you. So, the court is going to find that it's more probative than prejudicial. The only question now is what form you're allowed to ask the doctor questions about the lyrics.
Well, I would also just object, before we get into that, to the predicate of this being the sponsoring witness for it.
All right, So you're allowed to ask this witness question about the lyrics. I don't think it would be appropriate at this time to play a video. So you are allowed to ask the witness questions about the lyrics. And the court is finding that it's more probative than prejudicial. And the court is finding that the witness stated that he did review that song and his music. All right, anything else before I bring the jury back in? Does anyone need a quick break? If you need it, now is the time, because otherwise I'm going to bring the jurors back in.
I think we're ready to proceed, Your Honor.
All right, let's bring the jurors in.
All right, sure.
Ready?
All right, for the jury.
All right, everyone, please be seated. State, you may proceed.
Thank you, Judge. Dr. Fabian, previously I was asking you about Taymor McIntyre's music. Do you recall that?
Yes.
And in particular, you evaluated this individual. By defense, asked you to evaluate him. Is that correct?
Yes.
And when you evaluated him, you reviewed some of his music, particularly a song called "The Race."
Yeah, I listened to, I would say, and watched some of the video. I have an understanding of the premise of the song.
Well, can you tell the jury what the premise of the song is?
Objection 705, 801, 802, 803.
That'll be overruled.
That he was on bond for a murder charge, and he was on house arrest, and I think cut his ankle bracelet and went on the run, absconded, and then getting traveled around the country.
Okay. And that's what the song "The Race" is speaking of. Is that correct?
Yeah, that's my understanding of it, yes.
And
Objection speculation.
Overruled.
and you also saw a video associated with that song. Is that correct?
Objection 705, 801, 802, 803.
Overruled.
I watched part of it.
Okay.
I had listened to it in more detail, just, but I saw just a blurb of the video. I didn't watch the whole video.
Okay. But in that video, it's Taymor McIntyre, is that right?
Objection, Your Honor, that's facts on evidence 705801.
Overruled.
It's my understanding that was him, yeah.
And particular lyrics from that song, do you recall hearing, but I ain't beat that case,
Objection,
bitch, I did the
705,
race.
75 and 802.
Overruled.
I'll repeat that, sorry, overspeaking. Some of the lyrics say, did you remember, but I ain't beat that case, bitch, I did the race. Do you recall that?
I do recall that line.
And what about the line, shoot a fuckboy in his motherfucking face?
I don't recall that.
What about, I'm little Tay-K, I don't think you want no action. You want action, you get turned into past tense. You recall that?
Your Honor, and as to the reading of all the lyrics into the record, I want my objections for all of these questions. It could be a running objection, 705, 801, 802, 803.
All right, those objections are overruled.
And Dr. Fabian, just, I'll repeat that. It says, and again, I'm not going to read all the lyrics that are associated with the song. I'm just going to read portions of it. It says, I'm little Tay-K. I don't think you want no action. You want action, you get turned into past tense. Do you recall that?
And I'm sorry, Your Honor, I wasn't clear. Is the court granting me a running objection?
Yeah, your objections, you're making them, I overruled it.
As I go?
Yes.
Okay.
I believe I recall that line.
And what about Smith & Wesson made by 9 with some compassion?
Objection, 705, 801, 802, 803.
Overruled.
I remember the Smith & Wesson reference.
And then what about this line? Fuck a beat, I was trying to beat a case, but I ain't beat that case. Bitch, I did the race.
Objection, 705, 801, 802, 803.
Overruled.
I recall that line.
And then the line, I'm gonna shoot, bitch, without a debate. I'm gonna shoot, you can see it in my face.
Objection, 705, 801, 802, 803.
Overruled.
I don't recall that line.
Okay. But if I ask you, again, you said that this particular song was about pretty much the defendant cutting off his ankle monitor because he was on bond for murder
Objection asked and
running-
answered.
Overruled.
and running around, I guess, running about throughout the United States. Is that correct?
I would agree.
And you also have knowledge that this song was written and released very soon after the murder here in San Antonio, Texas.
Objection, speculation.
Overruled.
Correct.
And so this song was written and released after the murder of Mark Saldivar, the individual here in San Antonio, Texas.
Object to speculation.
Overruled.
And I don't know if you know.
That's my understanding.
Okay, I guess maybe you don't know the victim's name, Mark Saldivar, but that's the name of the victim.
Yeah.
Okay.
No, I know. I'm aware of his name.
Okay, thank you. Now, you reviewed, as you stated earlier, several different things in this case. Well, let me ask you, you did review some of the materials associated with police reports that defense counsels gave you, is that correct?
Correct.
And do you know if they gave you everything associated with Taymor McIntyre?
I don't know that.
So I guess to say this is that just, they gave you everything that they gave you, but you don't know if there's other things out there associated with news reports or other songs
Your Honor,
or
I
other
object.
criminal history or anything like that. Is that correct?
This is inviting the witness to comment on things that are not evidence. Here's total hearsay.
Not a basis for his...
This isn't and it isn't something that was disclosed in the 702, 705 hearing.
Overruled. You can ask the question.
You can answer the question, Mr.
Yeah, sure. I mean, I have his criminal history. They gave me they provided police reports and then of defendant and family members, and I think some school records, the prior psychological evaluation, current indictment. Most of it was, I think, Arlington Police Department reports.
Okay, thank you. Now, you stated that, one thing I want to touch on is the pre-diagnostic study prepared for the Honorable Timothy E. Manikos. Did you review that from Tarrant County?
Yes, I did. Mm-hmm.
And in that report, I believe you stated in your testimony just previously that Mr. Taymor McIntyre had witnessed abuse between his mother and his father, like physical abuse.
Yes, I think he denied that in that report.
He denied that. So where did you get that information from then?
Well, he expressed that to me. I learned it from his sister that they witnessed it, and I believe a Arlington police officer had interviewed him about it.
Yeah, in this report, I mean, just to be fair, because you stated that he witnessed it, but that didn't come from him. That came from other individuals that he states he did not witness any abuse between his mother and father, at least physical abuse.
Objection, hearsay, and asked and answered.
From the report.
That's the problem with the hearsay.
You can answer the question.
You can answer the question, Doctor.
Right. Yeah, he had expressed that he had seen some domestic violence between his parents when we talked. And it's my recollection in Arlington Police Department domestic violence report that he was present during one of the incidents.
And so I'm sorry, I don't know if I heard you correctly, but you stated that when he talked to you during your interview, he stated that he had actually seen physical abuse then?
Yes. Yeah, at one point in his childhood, yes.
But yet, he answered that in the negative when he was being evaluated for this pre-diagnostic study. You're aware of that, right?
Objection, asked and answered.
Overruled.
Yeah, I said I was aware of it, yeah.
Okay, so he changed his mind, or was he lying?
Objection, Your Honor. Argumentative.
That would be sustained.
Motion to instruct the jury to disregard.
Ladies and gentlemen, you disregard that last question.
Motion for mistrial.
Denied.
And,
Well, the Arlington...
Just one
Sorry.
second. The objection has been sustained.
Oh, thank you.
and I just wanted to be sure that sexual abuse was brought up, but I didn't know if you answered that. The sexual abuse was just brought up, and I'm not saying that there was anything there, but was there any sexual abuse that you're aware of?
No.
Okay, thank you, sir. Now, the psychological evaluation of Mr. Taymor McIntyre, I believe you were talking about that. You remember that?
Yeah.
And do you recall, one, if somebody witnesses a murder or anything, that could be a factor in them psychologically, I guess. Could that affect somebody?
Yes.
Okay. And so, do you recall from that report that Taymor apparently had been questioned but released by the Denton Police Department about a murder of a college student in
Objection,
early
Your Honor.
2016?
Hearsay, relevance, 403
705.
and 705.
All right, we're gonna have parties approach.
And step for step.
You may proceed.
Thank you, Your Honor. You're aware that he was questioned by Denton Police Department and released about a murder of a college student in early 2016.
Yes.
And
And
Did you
parties
talk-
approach, just 1 second.
just want to clarify this, that Taymor McIntyre was questioned as a witness on the murder of that college student.
That's my understanding.
And do you know any other information on that case?
I had read about it briefly, but I can't verbatim describe the facts.
Okay, we'll move on from that. Then, as you stated, that you did review some police reports from Arlington Police Department. And
Yes.
in particular, the police report that speaks about a robbery, aggravated robbery on May
Your Honor, I'm going to object 705, hearsay, confrontation, and relevance 403.
All right, with regards to that question, that objection will be sustained.
Motion to instruct the jury to disregard the question.
All right, ladies and gentlemen, you can disregard that question.
Motion for mistrial.
Denied.
Now, did you see anything about Mr. Taymor McIntyre's gang affiliation?
Did I see anything about it?
Right, in the packet that defense gave you, indicating that if Mr. McIntyre was a member or associated member or self-admitted to gang affiliation.
Is that just what I reviewed or my evaluation with him?
It was just what you reviewed? Because I don't
No.
have your evaluation in front of me.
Sure. No, I did not see, I don't recall seeing gang affiliation references in collateral information.
So if this packet that defense counsel supplied to me has information in there about this individual self-admitting to be part of the Crips, that's just something you may have overlooked.
Objection, Your Honor, that's an improper question. It assumes facts not in evidence.
Call the roll.
No, he and I already talked about his gang involvement, so I knew that separately.
Speaking of the gang involvement, so what did the individual say about his gang involvement?
Well, he acknowledged that his family was heavily involved in the Crips in Long Beach, that faction, and that he was also involved. He had a bunch of family members, his mother, uncles that were involved in the Crips Long Beach gang faction. So I think that was a big part of his involvement.
Okay. Now you... Sorry, what? And I was wondering, do you take into factor, what factors do you take into consideration of whether this person, Taymor McIntyre, has one, at this age, a fully developed brain? How do you determine that?
Good question. I mean, when we're looking at studies, functional and structural MRI studies of the brain with adolescents, we know based on research that their brains are still developing. So that's based on group data. Now, we don't have brain scans of him at age 16 or currently. At his age now, his brain would be, I would say, right at that edge of development, age 24.
So you would say that right now he has a fully developed, I guess, adult brain?
Yeah, for the most part, yeah. I mean, that's kind of my number. 23, 24 is when really that last area of the prefrontal cortex is developed. I would say that's correct. Some people disagree, but that's kind of where my number is.
I think you've said it throughout your testimony. Sometimes you say individuals are unique. Is that right?
Correct, in every different way. So no case is the same.
Right. So like in any given case, since you really don't have MRIs of Mr. McIntyre when he was 16, being unique people, I mean, some people could be developed at that age, some people cannot be developed. I mean, you're talking about a very stereotypical development, is that right?
Yeah, sure. Some people may have depression at that time and been suicidal. Some people may be more mature. Some people may have, ADHD. So everyone's really, really different.
So it's sort of difficult to say whether Mr. McIntyre at that time had not had, one, a developed brain in the sense of like knowing, let me ask you this, let me retract that question. At that age, right and wrong, does he know the difference?
Yeah, he's 16. He would know the difference between right and wrong.
So, for instance, you reviewed his history up in Tarrant County. You're aware of it, correct?
Right.
That on July 26, 2016, there was a home invasion and associated with the murder.
Yes.
And that he was part of that group of people that did this.
He was, involved. He was there, yes.
And that we already spoke about when he was on bond and he cut off his ankle monitor. And you're aware that he came to San Antonio then. Is that right?
Yes, I understand.
And that he was in San Antonio for a bit of time. I'm assuming you don't know exactly the time he was here. Is that correct?
I'm not exactly sure.
Okay. And then he committed the murder of Mark Saldivar in April of 2017. You recall that?
Yes.
Right?
Yeah, he was. I think he was in the area, obviously, around then.
And then he took off and was found in New Jersey. That's where he was apprehended in June of 2017.
Yes.
And so then he was transferred to Tarrant County to face those charges of the murder up there.
Right.
And subsequently, in 2019, he was convicted of that murder up there.
Your Honor, we're getting kind of far afield, and I'm going to object to relevance to this witness.
Relevance.
Your Honor, I'm just going over a timeline because he said he reviewed this. I just want to make sure he reviewed it because, one, I believe in testimony earlier, some of the material that I have was not supplied to him. And I just want to make sure.
I'm going to object to the speaking objection, Your Honor.
All right, the objection
being-
to the question is overruled. You can ask your question.
Thank you. So, you're aware then in 2019 he was convicted of that murder up there, and then also was convicted of an aggravated robbery up there. Do you recall that?
Yes.
And then that's when he was transferred down to the Bexar County to face the issues here. Is that right?
Correct.
And then you stated that you interviewed him, I believe, I want to say April of 2025. Is that right?
Yes.
So this month you interviewed him?
Yes.
And everything that you just testified to is based on that interview that happened this month.
Yeah, whatever my evaluation was based on an interview and information provided to me this month.
We'll pass the witness, Your Honor.
Defense?
Doctor, you were asked about the differences and the uniqueness of each individual person. Do you recall the prosecutor asking you about that?
Yes.
And he was asking about the possibility about brain development being more advanced than what you've testified to as sort of the norm for a 16-year-old. Do you recall that question?
Yes.
Do you know of any studies that have found 16-year-olds that have fully developed brains like a 24, 25-year-old person?
Not offhand, I can't reference one. I'm familiar with the imaging studies on adolescent brains and more involved with the prefrontal cortex area.
It is not something, would you feel unable to properly assess forensically the questions we've talked about today without an MRI to determine whether someone's brain was more advanced?
Well, no, but obviously if we did a brain MRI this week, it would not be when he was age 16. So I think things would be quite a bit different in his development, in the developmental years, neurodevelopmental years.
What I'm asking is, is it outside of the practice norms for someone in your field to base your conclusions upon the generalized data of how most 16-year-old brains develop?
No.
Okay. You were asked about these song lyrics. Did that play any role in your evaluation of Mr. McIntyre or about the situation that
No. I'm when I've been evaluating this case, again, from a mitigating standpoint, the information that I reviewed in my evaluation with Mr. McIntyre has revealed the same, neurodevelopmental risk factors, but also the issues related to trauma and just really the way he was raised. That's really what I'm interested, concerned about. And I think the offenses and the song all come with all of that.
Okay. So it doesn't change your opinion one way or the other?
No. I mean, no. It doesn't. I'm not basing my evaluation on a song he wrote.
And to be fair, do you even know if he wrote it?
No, I assume he did. I can't really prove that.
Pass the witness.
Judge, what would be your approach?
Yes.
No question, John.
All right, is this witness excused?
By the defense, yes, Your Honor.
Excused?
By the state, yes, Your
All right, the rule has been invoked. I know you know what that means. Thank you so much for zooming in.
Thank you, Judge. Have a good day.
Thank you. All right, call your next witness.
Defense calls Kayla Beverly.
Does anyone need a break before this witness? Sit here, please. You have a seat. Can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. If you make sure you speak in the microphone so members of the jury can hear. And then there's a clip on for the court reporter. All right, if you'll state your name for the record and spell your last name, please.
Kayla Beverly. My last name is Beverly.
All right, defense, you may proceed.
Thank you, Your Honor. Good afternoon, Ms. Beverly. How are you?
Good, and you?
I'm well, thank you. How old are you?
27.
And do you know Taymor McIntyre?
Yes, sir.
How do you know him?
That's my brother.
Is he your older brother, younger brother?
Younger.
How many years separate you two?
A year and a half to 2 years. It depends on when our birthday falls.
Okay. I want to ask you a little bit about your childhood and Taymor's. Could you tell us a little bit about your early childhood?
We were taken from our mom by CPS, and we had to live in foster homes and bounced around a lot.
How old were you when you were taken from your mother?
I believe I was 5.
5. So Taymor would have been how old?
Well, I believe that Taymor was 5 and I was about 7.
Okay, gotcha.
Yeah.
Before that, did both your parents live in the house?
Yes, sir.
Okay. Did that stop at some point? You said just you were taken from your mom.
Yes, my dad was incarcerated for domestic violence against my mom.
Okay. Do you know anything about that incident? Do you remember it?
I remember seeing my mom after, like injured.
Tell us about that. Would you?
I just remember seeing our mom afterwards. She was injured really bad after she was hospitalized. Stuff like that.
Was Taymor around for that?
Yes, sir.
And you said your father was incarcerated. Do you know if he went to prison for it?
Yes.
Okay. And so after he went to prison, did you all stay with your mother for some period of time, or did CPS get involved immediately?
For some time, maybe a couple of years, 1 or 2 years or something like that.
Just living with your mama?
Yes, sir.
What was that like?
We moved around a lot, kind of. I think she was trying to find stability, but didn't have a lot of help.
Okay. So you mentioned that eventually Child Protective Services got involved.
Yes, sir.
Can you tell us more about that? What happened there?
One day they came and they took us from our mom, and we fought with them and cried, and then they put us in a orphanage.
Okay. And you said that this was a couple of years after your dad was locked up? If you need a moment, that's okay.
Thank you.
So, how old do you think you were when you went to the orphanage?
I think Taymor was 5 and I was about 7. That's when they took us from our mom.
When they took you from your mom? Okay. And was that orphanage in Texas or was that someplace else?
It was in Las Vegas, Nevada.
Do you remember the name of the orphanage?
Child Haven.
Child Haven?
Yes, sir.
And describe to the jury what Child Haven was like.
It was like it was buildings, like different buildings in a property that was gated, and like the different buildings hold different kids of different ages. So me and Taymor were separated at that place for some time, and we were allowed to get visitation with each other, but we couldn't leave there. We went to school there, we ate there, bathed there, and sleep there. And sometimes we get visits. I think we got a visit one time.
It kind of sounds like a jail. Is that fair or is it not like that at all?
Yeah, it was. It's like a jail.
How long were you there?
As a kid, I didn't understand time, so it felt like a year, but it might have been like 6 months or something like that, close to a year.
You're not really sure, but
No, I'm not sure.
Felt like, I guess.
Yeah, it felt like a year.
What happened to get you out of the orphanage?
They placed us in a foster home. They found a foster home for us
Where was that?
in Las Vegas, Nevada, in a neighborhood, low-income neighborhood.
And you and Taymor were placed together in the same home?
Yes, sir.
Can you tell us a little bit about what it was like living in foster home?
We weren't happy, so it was sad. We just wanted to go home.
Did you have any contact with your parents?
No,
Did you know what had happened to your parents?
no. It was times we didn't even know if our mom was still living.
How long were you living with that foster? Was it a family or was it a single person? Do you know?
It was I believe she was married and eventually her husband passed away, but it was a married woman.
And what was daily life like with her?
If it was during the year, then we go to school and we come back after school. If no extracurricular activities, and if it wasn't during the year, then we have to be in her home at all times, not allowed to ever leave.
You couldn't leave her property?
No,
Taymor too, or just you?
neither one of us, Taymor either.
What happened if you tried to argue with her about that?
She didn't allow it, and we were young, so we just did.
Do you feel like you were provided for there?
Provided for because we ate every day and had a place to stay, so yeah.
What about your emotional needs?
No, not at all.
How long were you with this woman and her husband before he died?
I believe that we were with her for up to 2 years at the most at one point, and then we got transferred somewhere else and sent back to her again. So over the years, we were with her 2 times, the length of time that we were in foster care.
So you were transferred from her care to another foster home or transferred back to the orphanage, or how did that happen?
We were transferred to our grandfather family.
Okay, tell me about your grandfather.
He's a retired veteran. I don't know his age, but he took good care of us, and he's a good man.
What's his name?
Russell Hardy,
And where does he live?
in Waco, Texas.
Okay, and that's where you all went to stay after you left Las Vegas?
Yes, sir.
Taymor came with you, I guess?
Yes, sir.
Tell us a little bit about what life was like living in Waco.
We were allowed to be kids, and we were happy for the time span that we were out there. We were happier than we ever been as a kid in foster care or any of that stuff.
How did Taymor take it living with your grandfather?
He took it better. He started to get better grades, and and things like that. My grandpa was more involved in his school with his teachers and stuff like that. So eventually he did start to be better, do better and be happier, like a happier kid, more do extracurricular activities and just be a kid.
And about how long did this period of time last where you lived in Waco?
Maybe a year or so.
What happened after that?
They took us from our grandfather's care and sent us back to Las Vegas to Child Haven.
When you say they, who was they?
CPS.
Child Protective Services?
Yes.
So you went back to Child Haven?
Yes.
Do you know why they sent you back to Child Haven from your grandpa's house?
They never really explained it to us as kids. They just said that we would be coming back, so that it was just temporary.
Did you come back?
No.
When you got to Child Haven, the second time, how long were you there for?
Just one day.
Okay, just one day. What happened after that?
They sent us to the same foster home that we lived in before.
The woman that you mentioned?
Yes.
Okay. What was it like when you went back to live with her?
It was the same, but I feel like this time we were older and we knew it was wrong. Like we learned, like how she would treat us.
Help me understand that more when you say how she would treat you.
Maybe like physically abuse us and mentally abuse us and accuse us of things we didn't do and couldn't have done, or so like 24-hour surveillance for us. Like it doesn't matter, we couldn't watch TV, have a phone, or nothing like that.
So are you saying that she hit you all?
She did.
Did she hit Taymor?
She did.
When you talk about mentally abusing you, you talked about not being able to leave. Is that what you mean, or do you mean something else?
I mean just overall, because we were young and we were kids, so it was like a weird feeling with her because we wanted her to love us, but she was always disappointed at us, and we would get accused for things that we didn't even do. So it was just like, I feel like that was like mental abuse, because it was like we just wanted to earn her love, like be really respectful to her and not do anything wrong, but we would still end up in trouble.
What kind of things did she accuse you of doing, or accuse Taymor of doing?
Maybe, well, it was every kid in the house, but maybe like picking at carpet, like if normal wear and tear on the carpet, if it's older, like maybe we did it, we picked it out the ground, or maybe like we scratched a scratch on a wooden furniture that's older and wear and tear. It was things like that.
You made it sound like it wasn't just you and the woman who took you in. Were there other people living in that house?
It was other kids. They were all siblings. So 3 other kids that were all siblings.
Okay, were they her children, or were they also adopted?
They were not her children. They were in foster care. She ended up adopting them.
Okay, and I'm sorry, I used that word adopted a little carelessly. Y'all weren't adopted, I take it?
No.
Okay, but she had adopted other children from the foster system?
We met them the first time we lived with her. The second time that we came back, she had adopted them and changed their names and everything like that.
I see. Okay. So, how long did this last where you were back with the lady in Las Vegas?
I don't want to say it was a year. I don't want to say it was a year.
During that time period, did you have contact with any of your biological family?
This time we were allowed to occasionally talk to maybe our grandfather or our uncle visited us before one time. And so, yeah, this time we were able to talk to family sometimes, yeah.
Were you able to talk to your mom and dad?
Not my mom, but my dad. Well, not even my dad. Maybe if I received a letter, but I don't think so ever. Not in her care.
So you said that you were there with this woman again for about a year?
The second time I feel like it was less than a year.
Less than a year, okay. what happened after that?
We ended up telling the social worker about her treatment the last time we lived with her and how it was still going on this time, because this time they let us have different type of workers that come and talk to us or take us somewhere to a park or anything. So this time we got closer with our workers and we let them know like everything that had been going on, so they switched us foster homes.
Okay, so the second time around, there were some social workers to oversee what was going on?
Right.
Okay. And based upon what you told to the social worker, what happened?
They removed us from her home,
Where'd y'all go?
a different foster home.
Okay. Tell me about that foster home.
It was better. We lived there until we were not in foster care anymore,
Where was that other foster home?
in Las Vegas, Nevada.
Okay. And do you all have any connection to Las Vegas, Nevada, besides that they took you to Child Haven and that's where you got put in the foster system?
No,
Okay. No relatives, no distant relatives?
no.
Okay. So you said that you lived with the second foster family until you were taken out of the foster system. What happened there to get you out of the foster system?
Our dad got out of prison and we were released into his care
And where was your dad living when he was released from prison?
in Arlington, Texas.
Okay. So that's where y'all went?
Yes, sir.
Tell me about what it was like to go to be with your father at that time.
At first it was supposed to be happy, but it was a lot of abuse and things going on.
Okay. Abuse towards you, abuse towards Taymor.
Abuse towards both of us.
Tell us about it.
About what he would do.
Yes.
What do you call it? Maybe like his punishments were too big for like the thing. Like if we got bad grades, then we would be punished. Like he would. It started off by maybe the whoopings got worse and worser, and then now it's not a belt. Now it's a 2x4, and we get a certain number of hits, and we get hit with it, and we have to lay there and we can't get up. And it was times when Taymor was younger than me, so Taymor was younger than me, and he would cry, and just maybe they would think he was over dramatic, so they would tie him down to an ironing board, strap him down, like stuff like that.
And you said that these were examples of over-disciplining you both for things in the house?
Maybe bad grades, maybe like, yeah, just bad grades and stuff like that. We weren't bad kids to be doing going and doing anything we didn't have any business. We were too young, and we moved around a lot to know what's going on in our outside world. We were just learning. So it would be stuff like bad grades and stuff like.
Were there ever any signs that you were being hurt this way, or things that other people would notice?
Yes.
Give me some examples.
Bruises, busted lips, noses. People have witnessed before.
Did any of these things ever come to the attention of your teachers or other adults outside your house?
Taymor's teacher noticed.
Okay. What happened when she noticed?
I wasn't there the exact moment. A certain teacher took maybe noticed Taymor and built a relationship with him. And one day he had some type of bruising or something on his face. I don't know what it was. I don't know if it was a black eye or what, but the teacher ended up asking him, and he ended up being honest with her, and the school intervened, and they called our dad and our stepmom. Our stepmom came to the school, and they ended up talking to us, saying that we can't have any contact with our dad, and they just released us to her the same day.
Okay. But she was living in the same house as your dad, or no?
Yes.
Yes, she was?
Yes.
Okay. So what happened after that?
After that, then we went home with her, and they told Taymor, we got in trouble, and they told Taymor that he had to say that he was lying.
Okay. Your dad and your stepmother pressured him to say he was making it up?
Yes.
Okay. So, did CPS ever get back involved as a result of that? to your
No.
knowledge? How long did all this go on, living with your dad?
Until I was about 16, 17, or by the time I was like 16 years old, then me and Taymor started to think about, we didn't want to live with him anymore, and we wanted our mom to live with our mom.
Where was your mom at this time?
I don't know where she was. We just were upset that everybody took us away from her. And then we just thought that we knew that she wasn't perfect, but, you know, just to have, like, wake up one day and your kids be ripped from you, or us being ripped from our mom, I felt like that wasn't helping her or us. Well, we felt like that.
So what did y'all do?
We started to think about living with our mom, or just, you know, living somewhere else around the time I was 16. And then by the time I turned 17, then we decided to leave.
So Taymor would have been how old around this time? 15, 16?
15.
Okay. You said you decided to leave?
Yes.
Did you leave?
Yes.
Where'd you go?
We went to Corpus Christi with our mom after some time. Initially, we first left and we stayed here and there, and then we left Arlington to go to Corpus Christi after maybe like a month.
And that's where your mother was living?
Yes.
How long did you stay with your mom?
I stayed not even one night. I came and I brought Taymor, and then I left.
Okay. So, when you took Taymor down there, did you tell your dad you were taking him?
No.
All right. You were trying to get him out of the house?
I felt like if I did not take Taymor and leave, then my dad would keep hitting us and he would get in trouble eventually. Somebody would notice, there would be nothing we could do about it, or he would hurt Taymor, or law enforcement would have to get involved, and they would have no choice.
And last time that happened to your dad, what happened to you all?
We went to foster care.
So, do you know how long Taymor was in Corpus Christi with his mom?
I want to say a month, maybe. Or a month. It couldn't have been longer than 2 months.
Where did he go from there?
Back to Arlington. He stayed with a friend and their grandmother.
Okay. How long was he staying with them?
I'm not sure.
Did you ever get to meet the grandmother?
I don't think I never met her. I think I've been there, but she was elderly. I think I never met her.
Okay. How was Taymor behaving around that time?
I mean, he was all right. How he was behaving, he liked to make music and stuff like that, so he wasn't having behavioral problems.
Okay. Now, eventually, did something happen to that older lady that you mentioned that he was living with?
She passed away.
Okay. And what happened after that for Taymor?
Then he went with other friends, or like had to figure it out on his own after that. He bounced around a lot, didn't have a place to stay.
What was your opinion of the kind of company he was keeping after he left that older lady's house?
I knew that if the circumstances were different, he probably wouldn't be around the same people.
Okay, but as far as those people are concerned, I mean, you know that some of them were drug dealers, right?
Right.
Some of them were violent.
I'm not object to leading here. It's the same.
What sorts of things were the people he was hanging around with like? Or what were they doing?
I didn't hang around them. I didn't like them. They didn't like me. So I didn't, I knew that it was I didn't like the way they treated him sometimes, or like whatever was going on.
How did
And
they treat him?
just not those aren't your friends. I could just boil down to, you can just tell some people aren't really your friends or want better for you.
Well, are you saying they took advantage of him, or are you saying that they were a bad influence, or how do you
I feel like so, because he was only 15 years old, and it's a bunch of grown people who are just,
So were these people older than Taymor?
yes.
Was it fair to say he was the youngest of that group? of people?
Yes.
And were these the types of people he was hanging around when he got arrested in Fort Worth?
Yes.
Now, as far as the case in Fort Worth is concerned, are you a witness to any of the facts of that case? I mean, were you there for the case?
I was in trial.
You watched the trial?
Yes.
Okay. Do you know what they're accusing him of doing specifically was?
I know that he did not even have a weapon of any sorts, and he didn't harm anybody. And I know that he was 15 years old, and pretty much.
And you got to watch the trial unfold?
Yes.
Pass the witness.
Ms. Beverly, I want to start off by saying I am sorry for the abuse that you had to witness, and I don't think that any child should have to witness that, but there are some things that I have to talk to you about, okay?
Yes, ma'am.
All right. So your brother, to your knowledge, he was born in Long Beach, California, is that right?
He was born in Macomb, Mississippi.
In Mississippi? Did you guys ever live in California?
Yes.
Is that with your mother?
Yes.
Okay. And then, is your mother from California?
Yes.
All right. Now, as far as how you guys ended up in Las Vegas, is that because you moved there with your mother?
Yes.
Okay, and as a result of that, you guys ended up in the foster system in Las Vegas, correct?
Yes.
Okay. Now, I know you stated that your brother's about 2 years younger than you, is that correct?
Yes, ma'am.
And growing up, I mean, you guys were very close, is that correct?
Yes, ma'am.
As a matter of fact, I mean, I think you would describe it as you two were kind of the only thing that each other had growing up, is that right?
Yes, ma'am.
All right. And so, I mean, you love your brother, that's correct, right?
Yes, ma'am.
And you don't want to see anything bad happen to him?
No, ma'am.
All right. Now, regarding your father, I guess you stated when you guys went back, or when you took Taymor down to Corpus Christi, I mean, you loved your dad, is that fair to say?
Yes, ma'am.
And you didn't want him to get in any trouble for the abuse that you guys were undergoing at his hands, is that correct?
Yes, ma'am.
Okay. And you guys have kind of reconciled with your dad since then, is that correct?
Yes, ma'am.
Okay, in fact, he was here watching the trial last week, right?
Yes, ma'am.
Okay. Now regarding you, I guess when you were about 17 or 18, did you get your own apartment?
When I was 18 years old.
Okay. And was that was located in Arlington, Texas, right?
Yes, ma'am.
Okay. And I guess the address to that apartment, it was 2216 Plum Lane. Is that right?
I don't believe so.
Do you know what the address is?
I thought it was Shepherd Oaks Drive.
Okay. Do you recall what the name of the apartment complex was?
Sutter Creek.
Sutter Creek. Okay. And regarding, I guess I'm gonna show you something real quick. Well, I Yes, and when you were living at that apartment complex, that's when Taymor picked up his case in Fort Worth, is that correct?
No.
No. At some point, when Taymor picked up his case in Fort Worth, he was released from the juvenile detention center, correct?
Can you say that again?
Yeah, so when Taymor was arrested up in Tarrant County, do you recall that?
Yes.
Okay, and he was in juvenile detention.
Yes.
Okay, and he got an ankle monitor, is that correct?
Yes.
And when he was released on an ankle monitor, didn't he go to live with you?
Yes, ma'am.
And that was at your apartment that you had?
Yes, ma'am.
Okay. Now I want to show you. Is that your brother, as depicted on the screen?
Yes, ma'am.
And was that photo taken at your apartment, the Sutter apartment?
Yes, ma'am.
Okay. And so, at the age of, I guess, 18, your brother, he went to go live with you and you were kind of taking care of him. Is that how you would describe it?
Yes, ma'am.
And I mean, you've done your best to be there for him, correct?
Yes, ma'am.
And to provide for him, correct?
Yes, ma'am.
And you allowed him to live with you, right?
Yes.
Okay. And I guess you described the environment that you provided for him at that time when he was on an ankle monitor as stable, right?
I described it as that?
Would you describe it as stable?
No.
But you were doing your best to provide for him as best as an 18-year-old could,
Right.
Okay. And so at that time when he's living with you, I guess he decides to cut his ankle monitor, is that correct?
Yes, ma'am.
Okay, and so he's no longer living with you, he cuts his ankle monitor, and he flees Arlington, Texas, right?
Yes, ma'am.
Okay. And so I guess previously you would describe your brother's stature at that time as small, right? He was a smaller individual?
Yes, ma'am.
Okay. And I guess at the time that you guys were living together, you've previously stated that you guys were sharing an iPhone at that time, is that correct?
That we were sharing an iPhone?
Or did you ever share a cell phone with him?
I don't even think we had phones.
Oh, okay. Do you recall an interview that you gave to Say Cheese, the social media outlet?
Do I recall it? Yes, ma'am.
Okay. Do you recall in that interview you said that you and your brother shared a phone at the time that he was living with you?
No, I don't recall.
Okay, and I'm going to show you some photos. Okay, so who is that depicted on the screen?
Me and Taymor.
Okay, and what is that in your hand?
A phone.
Okay, and was that taken at your apartment?
Yes, ma'am.
And what about there? Is that the same thing depicted?
Yes, ma'am.
Now, regarding the Fort Worth case, you said that you watched the trial up there, is that right?
Yes, ma'am.
Okay. And I guess you stated that your brother didn't have a weapon, is that correct?
Yes, ma'am.
And he didn't harm anyone, is that correct?
Yes, ma'am.
Okay. But somebody died up there as a result of the actions of your brother and his co-defendants, isn't that fair to say?
As a result of my brother's co-defendants?
Your brother and the co-defendants?
Yes, ma'am.
Okay. And I guess you've previously spoken out because your brother's co-defendants up in Fort Worth involved 2 female co-defendants, is that right?
Yes, ma'am.
Okay, and one of them, her name was Megan, is that correct?
I guess so. I'm not sure.
You're not sure? That's fine. But you know that there were 2 females involved, correct?
Yes, ma'am.
Okay. And I guess you've previously spoken out because you don't agree with the way that the court systems have handled your brother, is that correct?
No, ma'am.
You don't agree with that?
I don't.
Okay. Now, regarding the Fort Worth case, I mean, based on the evidence that you saw, isn't it true that your brother, enlisted these 2 females and there was an agreement for the females to enter into a drug house, unlock the door, and then allow your brother and the other co-defendants to go in there, is that correct?
Objection calls for speculation.
She testified she witnessed the trial.
That doesn't mean
I'm
that
like,
she agrees with
could
your
you all
representation.
approach? Right, you may proceed.
Thank you, Judge. So up in Fort Worth, your brother was acting with multiple co-defendants, is that correct?
Can you repeat that?
In the Fort Worth case, your brother had multiple co-defendants, is that correct?
Yes, ma'am.
All right, and the evidence in that case was that your brother and his co-defendants, the two females, entered into a drug house. They texted your brother and the other co-defendants that were not yet in the house and told them to come in, and the females unlocked the door, and at that time your brother and his other male co-defendants entered the house to commit a robbery. Is that fair to say?
I'm not sure.
Okay. And isn't it true that your brother in that case searched the house for drugs to take?
Wrong.
No.
He didn't
Was-
search a house.
He was in the home, isn't that correct?
He entered the home. Yeah.
Okay, and he admitted to the Tarrant County Police Department that he was searching for drugs during the robbery, isn't that correct?
Oh, I don't know.
Now, regarding the murder that we're here for today, I mean, you were not in San Antonio, Texas when that murder occurred, correct?
No, ma'am.
You were up in Arlington, is that correct?
Yes, ma'am.
All right. So you weren't in the car, right?
No.
You have no personal knowledge as to the facts of the murder that we're here for today, right?
No.
Okay. Now, I guess earlier you kind of said something that your brother liked to make music. I guess you would describe him as like a talented musician, is that correct?
He's artistic in a lot of different ways, drawing, music.
Regarding music.
Yes, music too.
Okay. And I guess, are you familiar with the song that he wrote called The Race?
Yes, ma'am.
Okay. And that song was released after the murder that we're here for today, correct?
Objection to 403, Your Honor.
All right, that objection will be overruled.
You can answer the question.
I don't remember the question.
The song The Race, it was released once your brother was apprehended in New Jersey, correct?
It was released after he was apprehended in New Jersey.
Yes.
Yes, ma'am.
Okay. And the song was released after the murder that occurred in San Antonio, Texas happened, is that right?
If he was in New Jersey, then yes, ma'am.
Okay. And I guess regarding that song specifically, I mean, the lyrics of the song is that your brother was evading police, isn't that correct?
Is that the lyrics of the song?
Yes.
I'm not sure.
You've never heard the song before?
I have, but I mean, I can't tell you what a person meant
Okay.
unless it was me.
Well, I want to know what is your take on the lyrics? So,
Objection, speculation.
All right, that objection will be sustained.
Motion to instruct the jury to disregard.
Ladies, the question has not been asked for them to disregard.
Understood, Your Honor.
and I guess at the time when your brother was in New Jersey, you're aware that he was posing in front of his wanted poster and taking pictures in front of his wanted poster, right?
I don't even think it was a wanted a poster, so I'm not sure about that.
As well, Your Honor.
All right, that will be overruled.
And I guess while your brother was on the run, isn't it true that SWAT went to your place looking for him multiple times?
Yes, they did.
Have you met with the defense team in preparation for your testimony today?
No, ma'am.
You've never talked with them on the phone?
About my testimony, no, ma'am. Or, sorry, I have, but I thought you were saying like about my testimony or anything like that. I've answered questions,
Okay, so you guys have met?
talked on the phone.
Okay, thank you for the clarification. And I guess regarding your brother, I mean, you've seen photos of him. Do you have knowledge of his affiliation with the Crips gang?
No, ma'am.
But you've seen photos of him during gang signs, is that correct?
Have I seen photos of him throwing gang signs?
Yeah, or videos?
We were foster kids. I don't really know a lot of gang signs myself, so I couldn't tell you
Okay.
what it is or.
So if there's been testimony that multiple of your family members are gang members,
They didn't raise us.
okay. So your testimony is you're just not familiar with gang signs.
I'm not.
I want to call your attention to the interview that you gave to Say Cheese. Isn't it true in that video that you said your brother be hitting them things regarding the gang signs?
I said he be hitting them things.
Yeah.
I don't even recall my Say Cheese interview because I just answered questions, but I don't recall saying that. I'm saying that I didn't.
And regarding that interview, I mean, were you paid for that interview or was it?
No, ma'am.
Oh, you were not paid for that?
No.
So I want to talk to you about some of the people that you said your brother was hanging out with back in the Tarrant County case. Is one of those people Jalen Bell?
Can you ask that again?
Yeah, so earlier when Mr. Hunter was asking the questions, you kind of talked about some of the people that Taymor was hanging out with that were a bad influence on him. Do you recall that?
Yes, ma'am.
Okay. One of the people that he was hanging out with at that time was one of the people Jalen Bell.
Not sure, but
But you're aware that Jalen Bell and your brother were pretty close friends, correct?
yes, ma'am.
And you have personally, I mean, you've communicated with Jalen Bell before, correct?
Have I ever communicated with him before?
Through him or his girlfriend, Dara Sanders?
Yes, ma'am.
Okay. And sometimes they ask you for money, is that correct?
No, ma'am. I haven't talked to them in over 10 years.
So if there's a jail call saying that they've talked to you and asked you for money from your brother, that's just not accurate?
You said it's a jail call of them asking me for money or saying that they did?
Saying that they did.
Well, they didn't.
Okay.
So I can't know what they said.
Okay. Now, regarding Jalen Bell, I mean, you're aware that he pled to ag robbery for his role in the aggravated robbery of Mark Saldivar, right?
Yes, ma'am.
Okay. And your social media profile, or on Instagram, your social media name is @RealSpecialK, is that correct?
Yes, ma'am.
Okay. And isn't it true that on your bio you still have 3 pimpies?
I'm not sure. I've been having the same Instagram for over 15 years.
All right, Ms. Beverly, I'm going to show you what's been marked as State's Exhibit P5. Do you recognize what that is?
Yes, ma'am.
Is that a photo of your Instagram profile?
Yes, ma'am.
Okay, and just regarding the bio, can you read for me what it says here and here?
Free Tay-K, free pimp, long live 2 Live.
All right, thank you.
I'm tendering to defense for inspection, but I'm offering State's Exhibit P5.
Objection and proper impeachment. I mean,
All right, if I could see the exhibit P5. All right, parties want to approach. Stage, you may proceed.
Thank you, Judge. So regarding your social media profile, I mean, on your bio, you have free Tay-K and free pimp, is that correct?
Yes, ma'am.
All right, and so you have no real interest in the family of Mark Saldivar getting justice for his death? and your
Objection,
brother's
Your
role in
Honor,
that?
argumentative.
Sustained.
Motion to
I've been
instruct
having the
jury
same
to
answer.
disregard.
Oh, sorry.
So, when either party makes an objection, just stop speaking, and I'll make a ruling on it. If you don't understand my ruling and whether or not you're supposed to continue to speak or not, just ask me.
Okay.
All right, the objection is sustained.
Motion to disregard.
All right, ladies and gentlemen, you're to disregard the last question.
Motion for mistrial.
Denied. As state, you may proceed.
Thank you, Judge. At this time, we've passed the witness, Your Honor.
All right, defense.
Fair to say you love your brother?
Yes, sir.
No one's suggesting that you're not hoping for something positive to happen to your brother, right?
Right.
Pass the witness.
No further questions.
Is this witness excused?
Yes, Your Honor.
Excused from the state?
Yes, Judge.
All right, the has been invoked. You're not allowed to discuss your testimony with anyone during the pendency of the trial. All right, thank you, you may step down. Defense, call your next witness.
May we approach, Your Honor?
Yes. Ladies and gentlemen, I'm going to give you a short break, and I'm going to have you all come back at 5:20. Everyone, please rise for the jurors. All right, so, defense, what item did you want admitted into evidence?
Yes, Your Honor, the defense intends to offer defense P1, which is the judgment of conviction of Joanna Reyes. The offense date listed on the judgment is April 1st, 2019, which is after Ms. Reyes' plea of guilty in this case to the tampering charge, and the sentence was imposed on April 22nd of 2020, and we're offering it.
All right, and state what's your objection?
Your Honor, the objection is one, the predicate has not laid, I mean, we don't know whose actual judgment that is. It states Joanna Reyes, but we don't have, there's a fingerprint and everything, but we don't have any authentic.
Their TCIC will absolutely confirm that that is the same Joanna Reyes as what they tendered to me at the beginning of the trial, and I had to give back to them. There's no concern there. And it's a self-authenticating document certified by the clerk in Harris County.
All right, here's what the court knows. The court knows, one, that it's self-authenticating. I understand the state's objection, because you really do have to tie the fingerprint to whomever the judgment belongs to. Otherwise, it could be any Joanna Reyes. Just because you have this doesn't necessarily mean that the party who's listed on the document is somehow attached to this case. So, is that your only...
Well,
Is
we're
the state-
also objecting to relevance at this stage of the trial. Joanna Reyes did not testify in the punishment phase. The jury has already chosen that they believe her testimony, and so I think it's proper and untimely.
And we can get to that, and I understand that objection, but I really want to address the first one. Is the state meaningfully arguing that the judgment and conviction on that cause number in Harris County, which will match their TCIC records, is not an authentic representation of Ms. Reyes' prior criminal history? Because this was our concern as well in the closing argument, when the state told the court, and this is its relevance, so it's sort of a twofer. The state told the jury that Ms. Reyes had abided by the conditions of her bond while she's been on bond in this case. And this is direct evidence that that is not correct. We maintain that the state has its own independent obligation to set the record straight as to that. That was our objection at the guilt-innocence phase. But additionally, the document that would corroborate that the judgment in the court's hands is reflective of the same person that was called would be the TCIC and CIC record, which the defense is not able to make use of as an exhibit for the reasons that we had a hearing about at the very beginning of the trial. And so I don't know that fingerprint authentication is the sole means of admissibility, but irrespective of that, I don't think that the state should be taking the position that that is a predicate that we are required to lay when there is a, I guess, statutory, we obviously dispute this, but just a physical reason. We cannot admit the records in their file to corroborate it. You don't have to prove up the judgment by a fingerprint. That would also go to its weight, not its admissibility. And as to relevance, again, Your Honor, Ms. Reyes' credibility is still an issue at the guilt-innocence phase, because one of the questions in the case is whether or not there was sudden passion, and why this homicide occurred and the surrounding circumstances of it are relevant to punishment, and those are things that Ms.
I'm
Reyes...
sorry, Deputy Laura. Deputy Laura? Yeah, tell her now, because we have to go to the charge.
gave testimony about, and that testimony will have to be discussed in the closing argument here. So, for those reasons, we think it's relevant.
All right, the objection is sustained.
If the court would receive that into evidence, and what I just proffered to the court, I would like to be made a bill of exception.
Yes, and if you would then label it so that the record is clear, you can label it as P1R or P1B.
I can mark an R on it, Your Honor.
All right, thank you. That way it won't be confusing for the record.
So I'll label it as Defendant's Exhibit P1R.
All right. And are there any other witnesses from either side?
No, Your Honor.
All right, so what I'm going to give to you all, and we can go off the record. I'm going to print off, I'm just going to do 2 copies. And then if it's the one that you all want, because Barbara just sent me one.
Taylor, Beverly?
Yeah.
Okay, yeah.
So we have an issue with our Mexican coming back in.
So, yeah, we're resting, any issue, anybody different?
All right, so, defense, I'm assuming you're going to want sudden passion.
We're requesting sudden passion, Your Honor. I reviewed the charge that was on our desk this morning. It looks good to me. The only thing I saw missing, and maybe it's there somewhere else, is that the jury is instructed that they have to be unanimous as to sudden passion. But I didn't see a separate paragraph that told the jury that they have to be unanimous about whatever punishment they give, whether they find sudden passion or not.
Okay.
And we'd request that there be a general unanimous instruction as well. But other than that, I have no problem with.
All right, so this is what Barbara has just sent me, and if you both can look over it and state what I will tell you is I'm inclined to give the defense the sudden passion argument.
Yeah, Judge.
Okay. All right, let me see here. Okay. All right, so defense state.
Yes, Your Honor.
Hi, Barbara is looking to see if it's actually in here, and I'm looking as well.
The unanimity thing?
Yes.
Thank you, Judge.
All right, she's saying that the last line, it says, in any event, your verdict must be unanimous.
Okay.
It does. We see it, Your Honor.
Which page you have?
It's where they sign it.
It's right above my signature.
Oh, I'm sorry, the judge.
Yeah, okay, great.
All right, perfect. So then what we'll do is we'll bring the, okay, thank you, Barbara. Let me print out one more.
Yeah.
And then what we'll do is we'll bring the jury in and both sides can rest and close. Let's go on the record briefly. All right, it's the court's understanding that both sides are going to rest and close and there are no further witnesses for this part of the trial. Is that correct, State?
Yes, Your Honor.
Is that correct, defense?
That's correct,
Have both parties had a chance to review the charge of court for punishment, State?
Yes, Your Honor.
Defense?
We have.
Any objections, State?
No, Your Honor.
Defense?
No, Judge.
All right, we can go off the record. So I said I'd give both sides 15 minutes, and if you need more time, then I'll give you a little bit more time. Does anybody want a time announcement? 2 minutes?
2 minutes would be great.
Okay.
2 minutes on both.
All right. And are you all splitting time up?
If I could just have 5 minutes and you can just let me know when I've.
Reached your 5 minutes? All right, let's bring the jurors in.
Brittany. All right, for the jury. Going to the vending machine? Let me go outside. Judge, she went to the vending machine. I don't know if she knows how to get back.
Okay. All right, well, we'll bring the,
So come on.
yeah, okay. All right, everyone, please be seated.
Everybody's here now. All right, to the jury.
All right, everyone, please be seated. Defense, call your next witness.
Defense rests.
State.
State closes, Your Honor.
Closed.
All right, ladies and gentlemen, you've heard all the evidence that you're going to hear at this phase of the trial. I'm going to read to you the charge of the court on punishment. You do not have to memorize it. You'll be given the original when you begin your deliberation. Members of the jury, by your verdict in this case, you have found the defendant, Taymor McIntyre, guilty of the lesser included offense of murder. It is necessary that the jury assess the punishment for this offense. When a defendant is convicted of murder, the defendant may raise and prove by preponderance of the evidence that he caused the death under the immediate influence of sudden passion arising from an adequate cause. Adequate cause means cause that would commonly produce a degree of anger, rage, resentment, or terror in a person of ordinary temper, sufficient to render the mind incapable of cool reflection. Sudden passion means passion directly caused by an arising out of provocation by the individual killed or another acting with the person killed, which passion arises at the time of the offense and is not solely the result of former provocation. The term preponderance of the evidence means the greater weight and degree of credible testimony or evidence introduced before you and admitted in evidence in this case. If you unanimously find that the defendant has proven by preponderance of the evidence that he caused the death of Mark Anthony Saldivar under the immediate influence of sudden passion arising from an adequate cause, the special issue is to be answered by you in the affirmative. If you unanimously find that the defendant has not proven by preponderance of the evidence that he caused the death of Mark Anthony Saldivar under the immediate influence of sudden passion arising from an adequate cause, you will answer the special issue in the negative. Now, bearing in mind the foregoing instructions, if you all agree that the defendant proved by preponderance of the evidence that the defendant, having committed the offense of murder, caused the death of Mark Anthony Saldivar under the immediate influence of sudden passion arising from an adequate cause, you must make an affirmative finding as to the special issue, and the punishment you must assess is by confinement in the Texas Department of Criminal Justice Institutional Division for any term of not more than 20 years or less than 2 years. If you all agree that the defendant did not prove by preponderance of the evidence that the defendant, having committed the offense of murder, caused the death of Mark Anthony Saldivar under the immediate influence of sudden passion, arising from an adequate cause, you must make a negative finding as to the special issue, and the punishment you must assess is by confinement in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 5 years. You are instructed that your finding on the issue of sudden passion must be unanimous. That is, you must unanimously agree that the defendant either did or did not act under the immediate influence of sudden passion arising from an adequate cause. In addition to imprisonment, an individual found guilty of the offense of murder may be punished by a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict. If you assess a fine, it is not paid to the victim or victims, if any, but it is paid into the registry of the court. If there is any evidence before you that the defendant may have committed an offense or act of misconduct other than the offense of which you have convicted him, you are instructed that you may use that evidence, if any, in assessing punishment in this case, but only if you find from the evidence beyond a reasonable doubt that the defendant committed such other offense or act of misconduct, if any. In the event you have a reasonable doubt as to whether any other such acts, if in the event you have a reasonable doubt as to whether any other such offense or act of misconduct was committed, or as to whether the defendant was involved in such other offense or act of misconduct, then you will wholly disregard the evidence, if any, which may relate to any such matter. When there is a possibility for a defendant to incur multiple punishments on separate offenses, whether those sentences run concurrently or consecutively, that is, at the same time or one after another, is a decision to be made by the court. You are instructed that the defendant may testify on his own behalf if he chooses to do so. But if he elects not to do so, that fact cannot be taken by you as a circumstance against him, nor prejudice him in any way. The defendant has elected not to testify in this punishment phase of trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to fix the same by lot, chance, any system of averages, or any other method than by a full, fair, and free exercise of the opinion of the individual jurors on the evidence admitted before you. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law eligible in this case, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less. If the defendant is sentenced to a term of less than 4 years, the defendant must serve at least 2 years before the defendant is eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. Suitable forms are attached hereto for your verdict if you should care to use the same. However, such forms are not intended to influence you in any way in arriving at your verdict. In any event, your verdict must be unanimous, in writing, and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. Are parties ready to proceed with closing?
The state's right here.
Yes, Your Honor.
All right, State, you may proceed.
Not all murders are created equal. That's probably the only thing that me and Mr. Hunter can agree about throughout this whole trial. Ladies and gentlemen, Mr. Hunter is going to get up here in a couple of minutes and ask you to give the defendant 2 bodies for the price of 1. That is not justice, and you need to consider that in your deliberations. The defendant is charged with murder. His punishment range is 5 years to 99 years or life in the prison, and up to a $10,000 fine. The evidence in this case does not support a sentence of less than life. The defendant has taken an active role
in the death of 2 individuals, not only in this county, but in Tarrant County. And you all need to send a message to our community and to all other criminal defendants out there that they can't just come into Bexar County and do whatever they want.
Appeal to the community.
It's a plea for law enforcement, Your Honor.
Overruled.
Mr. Hunter's gonna get up here and he's gonna tell you the defendant is counting on you. But ladies and gentlemen, our community is counting on you. The family of Mark Anthony Saldivar
Appeal
is
to
counting on
community.
you.
Overruled.
The evidence in this case does not support a finding for sudden passion at all. There's been no evidence that the defendant was acting under sudden passion. And when you are considering that, you need to look at the person or a person of ordinary temper. And what does that mean? Well, you need to look at the defendant and how he holds himself out in our community. And how is that? As a Long Beach insane crip that goes under the moniker of Tay-K 47, that writes rap songs about evading police after committing 2 murders, that doesn't surrender himself to law enforcement, has to be apprehended in New Jersey. Ladies and gentlemen, that throws gang signs repping the folks and the insane Long Beach Crips. That's not a person that has an ordinary temperament. Even you heard from Dr. Fabian, he said that the defendant struggles with having an aggressive personality and he's more at risk than other individuals in our community. Now, regarding the role of parole, you may consider the existence of the parole law. The defendant's length of the sentence may be reduced by parole. And so that's something that you can consider. We don't know if he will get it. He will be eligible at halftime, and that's something that you need to consider during your deliberations.
I object to that last statement, Your Honor. That's...
You may
not
consider during your deliberations. Ladies and gentlemen, your verdict changes this community, and I want you to think about the evidence that you've seen in this case. What we know is that the defendant has played a role, 1 as a party and 2 as the active shooter and 2 murders. And he's taken no accountability for it. He comes up here and he's asking you all to take sympathy on him because he had a rough upbringing. And I do sympathize with that. But that's a slap in the face to every other child of abuse that chooses to be a law-abiding citizen in our community. And it's not just 1 mistake, it's 2 intentional choices that he made. And you all need to consider that, seriously. Ladies and gentlemen, the only appropriate punishment verdict in this case is life.
Thank you, Your Honor. Opposing counsel, may it please the court. Ladies and gentlemen, the concept of community, I think, is an important place for us to start because it tells a certain story. The state wants you to come in here and send a message to the community, and a harsh message. But how do we send a message to the community to address the sorts of systemic problems that result in someone being the victim of child abuse, being snatched up and taken away to what is essentially a carceral institution, an orphanage where they can't leave, away from their parents, that locks these people up, that puts them in foster homes where they're mistreated, that confuses them about who are their caregivers, who are their providers, that bounces them around from disaster situation to disaster situation. You can blame parents, you can blame the overarching structure, but at the end of the day, we also, I think, have to look at ourselves. We have to look at what this society does. And we can all recognize, I hope, that what Kayla Beverly testified to, that she and her brother Taymor went through as children, is not doing what we expect of the foster system, of child protective services, of moms and dads. The societal problems that we have to recognize these children are growing up in is all of our responsibility just as much as it is our responsibility here today to make a decision about how to punish Mr. McIntyre. And it's an easy fix for us to all just say, of course, man died, life for a life in prison, goodbye. But that doesn't answer those questions. And this isn't just a situation where we can accept that a tragedy has occurred and forget about all the things that led before. I'm not suggesting to you that what Dr. Fabian testified about in punishment in this trial is an excuse for what Mr. McIntyre did. It isn't. And of course, there are ample examples of people who have had terrible childhood backgrounds, like Taymor's, worse than Taymor's, who don't go out and commit murder. But it would be silly not to acknowledge that there is a cause and effect relationship. And to completely ignore that is all you'd be doing by giving a verdict of life in prison. You'd be abdicating any other bit of responsibility for how this tragedy played out. How it played out when he was a small child. How it played out when he was 10 years old. How it played out when he was 14 and 15. How it played out when a 16-year-old boy was expected to provide for himself and make his way in the world as though he was an adult. And it wouldn't account for the travesty that it is that we are sitting here in an adult court prosecuting a man for a felony as though he were 38 years old, 40 years old. That he should have known better, that he should have understood all of these things. And again, I'm not saying that there isn't an appreciation of right and wrong, but you understand that we have here a perfect storm of factors that ask for these kinds of things to transpire. And we need to make sure that the verdict that we deliver in this case is measured to that it acknowledges that this is a tragedy for a lot of different reasons, and only one of them was decided when that light changed from green to red on the access road of 410. That's the timing we're talking about. A decision that was made in that little span of time, impacting the rest of Mr. McIntyre's life and ending Mark Saldivar's life. And that tragedy, as I said to you in opening statement, cannot be undone. But we can avoid turning one tragedy into two. I'm asking for your mercy. I'm asking for your measured consideration of the evidence. And I'm asking you to think about some of the things that we talked about in the guilt-innocence phase of this trial as well, because those are still relevant factors. Irrespective of the fact that those things didn't lead you to the conclusion that he was not guilty, let's just understand what we're talking about here. We have a 16-year-old boy in a car with a bunch of people who are 2, 3, 4 years older than him. And out of that scenario, we have this entangled romantic situation. You hear evidence that goes uncontroverted. In fact, it's after 2 or 3 attempts at trying to conceal it that we tease out of Joanna Reyes the fact that she was flirting with this man on Instagram, that she was discussing with him a very provocative photo shoot, that this was something where they have had a history together, that they know each other from back in high school, that she's blocked him for making advances on her and soliciting her for photographs in the past. And the man gets into the car, and all of a sudden this photo shoot is called off or it's rescheduled. Okay, now that's the evidence. And the state doesn't provide you with a competing narrative of that. So even if you accept that Joanna Reyes is telling the truth, that Mr. McIntyre killed this man, and you accept that he did it for whatever reason, the bottom line is that Joanna Reyes got that man into the car, and that man had one thing and one thing only on his mind. And his decision to abort the photo shoot, to not go through with it, to act weird about it, provoked this issue. And again, I'm not trying to blame Mark for this. I just think we need to understand that Joanna Reyes shaved the tinder into the campsite. She poured the lighter fluid on the tinder, and she throws the match onto it. And now is trying to pretend that that didn't happen. And I think that that evidence is important for you all to consider for 2 reasons. The first is, it's the only evidence that you know about the true accounting of what happened in that car. Throughout both phases of the trial, that's the information you're possessed with. Well, in my mind, that evidence points us to sudden passion. It's the only evidence that we have about the transpirings of that car. So I would submit to you that's the great weight and preponderance of the evidence that's before you. And it suggests that there was a provocation for Mr. McIntyre's behavior. It's not a justified reason to kill somebody. It's inexcusable, losing your temper like that. But we have to couch it in terms of the whole context of what we're here to talk about. We're talking about a 16-year-old boy. We're talking about someone who doesn't have a fully formed brain. talking about someone whose decision-making skills and whose understanding of reality is tempered not just by post-traumatic stress from having an abusive childhood, but by the fact that he was intoxicated, or at least partially intoxicated. By the fact that he's had systemic problems with drug abuse as a child. We have to understand things as they relate to that. And we have to ask ourselves whether or not any of that should be considered at all as a matter of mitigation. This isn't some grown man who lost himself in the bottle and did something in a blackout rage. This is a child whose entire world was shaped by circumstances that were mostly out of his control. And now, at a moment where we freely acknowledge he exercised his own control and made a decision that was terrible, we're going to bring the hammer down on him and send him away for the rest of his life. Folks, let's try to be a more reasonable society. Let's try to make this courthouse, the juvenile justice system, child protective services, something other than a killing floor. We know that these problems are plaguing our society. We know that these problems are creating the risks and the jeopardy that these kinds of events will take place. But this is where we sit. I think it's very important that we understand that when we talk about if a message to the community, it really is that. At the bottom line, what the state wants us to do is to be able to say that this is a classic example that they did their job. We put a man away for life in prison because of a brutal murder. And it's not just one, it's two. This guy's been to prison before. And he's a bad guy, and he's written rap songs, and he's a member of the Long Island, or the Long Beach Insane Crips. Whatever they want to say about it, there's a propagandist function to the request that they're putting to you. Don't do it. Don't be a shill for the state's own apologetics. They're asking you to whitewash over their own failures. Our failures as a society. We're all in this together. And participating in it only at the end of the story, participating in it only when we get to come down and pass final judgment, is a cop-out. A message can go both ways. And I would submit to you, if we're going to send a message, that's a better one to send. Because it's very core. It's a message that communicates mercy, forgiveness, moving forward, recognizing that this person, Mr. McIntyre, is also a human being, that his dignity is just as important as the deceased, as Mark Saldivar's. That's just the reality of it. We can couch it in terms of right and wrong, we can point the finger, we can blame, but every human being has that same level of dignity. The Bill of Rights doesn't have an asterisk that says except for convicted criminals. Our founders recognized the inherent dignity of every single person. That's why we have these procedures, that's why we have these laws, and that is also why you all have such a wide range of punishment. There's a lot for you to consider here. I want you to also just consider again, to go back to it, that while you have rejected self-defense, and I understand that what we are critically talking about here is a bad decision in the face of a pretty significant circumstance. Defense exhibit number 5 is still in evidence, and it's still something I want you to go back and look at. And you're going to see that shattered windshield. And you're going to understand that this is what is being experienced by this boy in this moment. Are we right to say it's not good enough? That's not an acceptable reason to pull a gun on someone? Sure, I think that we can say that that's unacceptable. But we also have to understand that that's something that goes towards his decision making, and that this is a decision that happens in the blink of an eye. Milliseconds. Now we're here sitting here talking about years. Many, 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 many years. You've heard about Mr. McIntyre cutting his ankle monitor while on bond for a murder. You've also heard some testimony that Mr. McIntyre is not the trigger man in that case. Mr. McIntyre didn't act alone. Mr. McIntyre was in the company of older people who were bad company, who were creating problems for him. There seems to be a theme here of falling in with the wrong crowd, falling in with older people, and trying to take their direction. Before we can say that doesn't merit any consideration in what punishment to give him, we need to be asking ourselves, where were all of us? Where were we as a society? How did we end up here? Why are we letting these types of people have to depend upon the guidance, the counsel, and the decision-making of older criminals for their only source of support, for their only guidance, for how they're brought up, for their introduction to how to intoxicate themselves, what to do with their lives, how to behave, how to create, how to express. It's not acceptable. This is a weighty choice, because I fully understand everything the state's going to get up here and tell you, and everything the state said. Mark is a human being. Mark was entitled to that dignity. Taymor took it from him. That's worth something. I'm not suggesting it isn't. I'm just asking you to balance that against everything else that needs to be considered. Lastly, I want to talk to you about something that's a little bit more technical. You have here a judgment from Tarrant County where Mr. McIntyre received a sentence for 55 years, and then several concurrent sentences for accompanying offenses in the same transaction, which ran concurrent with that. So you understand, he's serving a 55-year sentence in prison as we sit here today, okay? I want to be clear about this. This isn't a situation where if you all express leniency and give him a low sentence, he's going to be out in a couple of years. I mean, to the extent that we can recognize that there's a valid purpose in carceral punishment for people who commit these kinds of crimes, understand that work's already been done. The issue that has to be considered is that whatever you all decide to do, the court has in its discretion the power to either run that concurrently with Tarrant County or to stack it on top of it, so that whatever you give won't begin to be served until all of that time has been satisfied, however it gets satisfied. So understand that. There's a lot of temptation in these sorts of things. It's almost like when you're negotiating for the purchase of a house and you're talking about 20,000 here and 40,000 here, and these are big numbers and they're being casually thrown around. When we're talking about something as significant as this, and where the options are 5 to 99 or 2 to 20, it's easy to start talking about numbers like 40, 30, 20, 15, 10, as if it was just no big thing. How do you mathematically quantify in your head the time that's spent in those places? And you heard testimony about what a jail's like. Try to understand. It's incumbent on you to just focus on this. Focus on this and know that there is a possibility in the court's discretion that it will be stacked. This gang stuff, don't fall for it. There's nothing to it. It's just trying to smear him in your eyes. There's no evidence that this particular group is in any way a criminal organization. It's just a thing on paper. And it betrays a very important fact about jail, about prison, about any kind of lockup like that, which is that it is survival of the fittest. It's a brutal place. There are no good people there to provide counsel. There is no way to get better. You have to live. You have to survive. And so, as a natural consequence of that, sometimes people join up with other groups of people. A lot of it's on racial lines. You heard that. That isn't a reason to think that Mr. McIntyre is any worse of a criminal, that he's a criminal at all, other than the things he's been convicted of. It's just a fact of life about these situations. But it gives you a glimpse into what you're sending him to. This isn't a resort. This isn't a country club. Prison is hard, and it is cruel. And there are plenty of people in this world who say, well, that's how it should be. That's how it should be. But I'm sorry. The 8th Amendment of the United States Constitution demands more. It expects that people don't get raped in prison. It expects that people don't have to trade in contraband in order to not be hurt, beaten up. It expects that people won't be shivved in the shower. But we know that those things happen. That's what we're sending them to. So appreciate that as well. You all have given us so much of your time, so much of your patience over the course of this. and I hope we haven't been wasting it. This is a very worthwhile thing for Mr. McIntyre. I know that when you deliberate, you will come to a fair and just sentence, one that is tempered by your compassion, by your love of your fellow man, and by your understanding that we are all in this together for good or ill. Thank you all.
Thank you, Your Honor. Thank you, Mr. McIntyre. Ladies and gentlemen, I'll be glad to speak with you. I'm going to try to make it as brief as possible. I know it's been a long 2.5 weeks for y'all, but we're here for a very important matter. The state of Texas versus Taymor McIntyre. I want to tell you, just start off with the charge of the court. This is what you'll receive, very similar to what you received during the guilt innocence phase. But this is what you'll receive back there, and the judge has already gone over it in the verdict forms. I've circled the part where the state believes that this is not said in passion. I've also circled a portion on the next where we're asking for life with a $10,000 fine. It's very few times that you're able to come up here and argue that the individual not only has the murder that you convicted him of, but also another murder that he was convicted of. It's not very often. So when you're looking at that range of punishment of 5 to 99 years of life, let's think about that. What the lower end, 5 years. Somebody that committed 2 murders deserve that? Plus ag robberies, gang affiliation, shoot a fuckboy in his motherfucking face. Fuckboy. Condoms. Lube. Who's he speaking of? Is Mark? That fuckboy that he shot in his motherfucking face? That family over there wonders that same thing. And he glorifies it in a song. That when he's on the run to beat the case, and then he posts it out there, glorifies this lifestyle. So 5 years, that's somebody that goes in and unplugs it. A plug from the medical device supporting their wife or husband that's dying of cancer and is pain. That's murder. You intentionally and not only did it. That's what that is. What's in between? 5 years and 99 years of life. 20 to 40 years? Maybe. Got 55 years on his last murder, and supposedly he wasn't even the shooter. 60 plus years? If you're the shooter, yeah. That seems appropriate. 60 plus. However, that's if you're just a shooter and not a repeater, meaning that you did 2 murders. He's done 2 murders, affiliated with 2 murders and aggravated robberies. If this doesn't call for life, then what does? Sudden passion. Remember where Mark was shot. He was flying off that car. He was shot in the shoulder. It went across his body. He was on his hands and knees. On his hands and his knees when he was shot by that man. In that parking lot. Mark had to jump on that hood to get back his stuff. And I understand you couldn't agree on robbery. But there's no doubt that Mark's things were in that car. No doubt. His wallet ended up to that Mexican food restaurant, thrown about by these individuals. By Mr. Taymor McIntyre, Tay-K 47. Person of ordinary temper. Tay-K 47. Ordinary temper. Anger, rage, resentment, or terror. An example of that is walking in on your spouse and they're with somebody else in your bed. You grab the gun and you shoot him. Sudden passion. You feel that. That's what sudden passion is. This is not sudden passion. Taymor's timeline of death here. July 26, 2016. Home invasion. Murder. He's on bond for murder then. He's given a chance to show that he can get on bond, be out in our community with an ankle monitor, and abide by the rules. But what does he choose to do? Cut it off, and let's go down to San Antonio, Texas, and murder somebody. Let's go on. He doesn't get caught here in San Antonio. He runs off to New Jersey to hide away, to release his song, The Race, because he had to beat it. He had to beat this case. That's what he chose to do. He was caught there and dragged back to Tarrant County and convicted of murder and 3 different ag robberies and received 55 years for the murder, 30 years for one of the ag robberies, and pled to 2 ag robberies and got 13 years on those, to run all concurrent. They're not stacked on top of each other. They're all run concurrent. They're all running at the same time. And now you convicted him of murder for the 2nd time. 3 ag robberies. He's affiliated with the Crip Street Gang, and continuing behavior of a gangster rapper style. That's what it is. You heard the lyrics. Who really treated somebody like trash? Look at that picture. Left in a parking lot with an orange and tangerine or bottle of water and marijuana and shell casing and the grime on his hands and the grime on his pants, the dirt. Who really treated somebody like trash that day? Who didn't treat somebody like a human being? This is human. This is humane. This is what we're doing. This is humane. We're not asking for you to go out there and shoot Taymor McIntyre. We're asking you to hold him accountable. 2 murders, 3 ag robs, 5 first-degree felonies. 5. The punishment phase is to deter this kind of action from happening again. It is for punishment. He took somebody's life. He took Mark Saldivar's life. We're not asking for an eye for an eye. Again, we're asking you to deter this type of behavior from other individuals wanting to be that type of individual. Big man with the gun. Walking around with the gun. If you want to talk about somebody, about the sexual innuendos that Joanne was having flirting, and then you want to talk about Taymor knowing about that's his girlfriend, and he goes into a rage because he was going to rape her because he brought the condoms and he supposedly brought lube. Well, we don't know. Why did Taymor want to set this up then? Why did he want to meet the guy that wanted to have sex with her before and she blocked him? Why? Never understood that. Why would Taymor want to meet this guy? Ask yourself that. Remember this. Taymor will one day speak. Well, he'll speak to his loved ones.
Your Honor, I object. This is an insinuation about parole in some kind of way. It's improper.
All right, that'll be overruled.
He will also walk among us one day. He will have his freedom. He will have his life. Maybe he's going to a bad place like defense counsel said, which that's what prison is. He has all those options ahead of him. He can choose to make himself better there. He can choose.
2 minutes.
Thank you, Judge. He can choose. Mark will not be able to choose any of that. He will not be able to choose to go to college. He will not be able to choose to get a degree. He will not be able to choose to use photography as a career. He will never, ever see his family ever again. They will never see him. It's a simple ask here is please assess a just verdict. A just verdict in this case, considering all the evidence that's been presented in front of you over the course of 2.5 weeks, is nothing less than life. Nothing less than that. Thank you very much, ladies and gentlemen.
All right, ladies and gentlemen, you've heard all of the testimony that you're going to hear in this case. Deputy Laura will take you back to the jury room, and of course, the alternates will be placed in a separate room. All right, everyone, please rise for the jurors. There will not be any outbursts in this courtroom. If there are outbursts in this courtroom, you're going to be asked to leave by the deputy. If there was a statement or something you're going to give, you're not going to be allowed to give it because you're going to be asked to leave the courtroom. Does everyone understand?
Yes, Judge.
And my understanding after this, Mr. McIntyre, after you're sentenced, that they want to have a victim impact. Who is going to be giving the victim impact? All right, so the advocate is going to be saying victim impact on behalf of the mother. What I can tell you in this courtroom, I always require everybody, treat everybody with respect. I know that this is a very emotional case for everyone, but I want the deputies to have an easy time this evening. And I just want everyone to please keep your emotions at this level, although I understand there's a lot of emotions going on both sides. And is Hunter on his way?
Should be shortly.
All right. And what is the cause number of the case out of the other county?
I'm sorry, Judge.
What is the cause number of the case out of the other county?
Out of county?
The judgment's back from the jury, Judge.
Ah,
Is it? Oh, yeah, okay, it's right here, Judge. Would you like?
yes, if you can just tell me.
It's 4 counts, Judge.
All right. Oh, just stay right there for 1 moment.
Sorry.
All right, we're going to go back on the record in 2019 CR 12495, State versus Taymor McIntyre. Could I have parties announced, please?
Jason Gearhan and Megan Galloway, State Guard.
John Hunter and Thomas Lane for Mr. McIntyre, Your Honor, he's present.
All right. Deputy Laura has informed me there was a buzz and that the jury has reached a verdict. Are both parties prepared to receive the verdict from the jurors?
Yes, Judge.
Yes, Your Honor.
All right, let's bring them in.
All rise for the jury.
Jill, will you come and step out? Okay.
All right, everyone, please be seated. All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict. Is that correct?
Yes.
And is that verdict unanimous?
Yes.
All right, Deputy Laura. Thank you. All right. It states that we unanimously find that the defendant, Taymor McIntyre, did not cause the death of Anthony Saldivar under the immediate influence of sudden passion arising from adequate cause. It states that punishment to be assessed at 80 years in the prison, and there is no fine. Does anyone wish to have the jury polled?
Not with the state, Your Honor.
Yes, Your Honor.
All right, ladies and gentlemen, I'm first going to start with your unanimous decision stating that there was no finding of sudden passion. If that is your verdict, I'll need you to respond yes. Does everyone understand?
Yes.
We'll start on the end. Is this your verdict? I'm sorry?
Yes.
Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict? Is this your verdict?
Yes.
Is this your verdict? I'm on the back row. I'm sorry. Is this your verdict on the back row? Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict? Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict? With regards to the sentence of 80 years in the prison and no fine, if this is your verdict, I need you to answer yes. Does everyone understand?
Yes.
Is this your verdict? Is this your verdict?
Yes.
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 Back row, is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict? Is this your verdict? Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict?
Yes.
All right, ladies and gentlemen, I'm going to have you go back to the jury room and I'll meet you back there shortly. Everyone, please rise for the jurors. All right, everyone, please be seated. All right, Mr. McIntyre, the jury found you guilty of murder. Your punishment is to be assessed at 80 years in the prison. The court will give you credit for any time served. There's a $0 fine. And with regards to the other offense, State, are you requesting that to be stacked?
Yes, we are, Your Honor.
All right.
Your Honor.
And I'm assuming you're against that, is that correct?
We are, Your Honor. We would just like to briefly, for the record, maintain that our argument would be that to run consecutively an 80-year sentence on top of 55.
Just one moment, counsel. Just give me one moment. Mr. McIntyre, I want you to know that I listened to all of the evidence in punishment and thought about whether or not your sentence should be stacked. I don't know where your mom is, don't know where your father is. I know that you had a rough childhood. And I do know that these offenses occurred when you were very young. And I understand the state of the law, what people consider an adult. I listened to the testimony of the expert that was brought by defense counsel. You've already been sentenced to murder in the other county, and then you have a murder here. And the sentence for 55 years, that's a stiff sentence. This 80-year sentence is a stiff sentence. And these are cases where you have to serve half your time, and that's day for day time, and I recognize that. Hopefully you will grow, but based upon his age, based upon the number of years that he has received out of Tarrant County and the number of years that he's received here, based upon his history and the lack of any type of good parenting. From what I can tell, his mother wasn't a good parent to him. His father wasn't a good parent to him. Child Protective Services was not good. And if you believe the testimony, I don't know why Child Protective Services would place children back with a father who put the children's mother in the hospital. Is there something else that needs to be done with our society? Yes. Is more money need for Child Protective Services and their workers? Yes. And I do realize that while this is a lot of time, and I tell people all the time, any time that you do in custody is a lot of time. But by that same token, you're still alive. And what the state has said is true. You're still alive. You can still better yourself. If you end up in prison for the rest of your life, you're still alive. You still can improve yourself. Your family can still visit you. But the complainant in this case is deceased. And you need to internalize that the complainant in this case is deceased and that his family is never going to see him again. So you're going to have to make changes. And you're going to have to remove people from your life who are not of benefit in the means of making you a better person. And I do understand that sometimes people will go to prison, they join gangs because you need protection, because you're there by yourself, you're young, but you're going to have to make better choices. Do you understand?
Yes, ma'am.
So I'm going to sentence him to 80 years in the prison, give him credit for any time served. There is a $0 fine. This will run concurrent with 1511547D. And is there any, I don't know if there's any restitution.
Judge, we'd be asking for restitution to the family.
May we approach, Your Honor?
Yes. And there's to be restitution, if any, to the complainant's estate. Is there anything else with regards to sentencing?
Not from this one.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, you do have a right to appeal as this was a jury trial. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, and also there's an affirmative finding of deadly weapon.
Judge, and you just ask for continued contact with her within the next 10 minutes.
Well, I guess I should say there should be no contact with the family outside of legal for the civil matters, okay?
Yes, Your Honor.
So there's to be no contact with the complainant's family outside of legal proceedings. All right, is there anything else from either side?
Not from the state.
All right, Mr. McIntyre, yes?
No, nothing else from the defense.
All right, Mr. McIntyre, there's going to be what is called a victim impact statement. I want you to listen to it, internalize what's being said. Do you understand?
Yes, ma'am.
All right, you may proceed. Cindy.
On April 23rd, 2017, we spent our final day together as a family, engaged in yard work. We had just moved to a new neighborhood and into our first house a month prior. Marky had been eagerly anticipating this day, looking forward to the day the grass would grow tall enough to mow it, because it was his. While we rested, he continued to work. He was diligent and a hard-working man. He helped others when he could and was always willing to lend a hand to anyone in need. After we finished, I could see the pride in his eyes for what he had done that day. He looked happy and was excited for our new life in our new home. When he left that day, I didn't know he was giving me his last goodbyes. A hug and a kiss that will stain my heart. I didn't know when I started to text him that I would be receiving one last response, that those would be our last words to each other. He never came back that day. My son was full of love, full of hope and ambitions. He had trust in the good nature of people. He was an entrepreneur. He had a love for the arts, music, photography, videography, people, and business. He had many passions. He was a lyricist, a photographer, and a businessman. He wrote poems, and he would synthesize and compose his own music and record his own lyrics. He was an angel to a few, but a friend to all. He was excited to build connections and help people reach their potential. He had a hand in nurturing and fostering his friends' passion for music, inspiring them to pursue careers in the music industry. This isn't a fair world, but there are rules. He put his trust in you, and when he got into that car that day, and his trust was betrayed, but he lived with hope and love in his heart, and I will carry that with me for as long as I live. My son desired to live in a city that loved him. My son desired a brighter future for himself, his family, and others. He hoped for something better than this. My youngest son, Mark Anthony Saldivar's life ended on April 23, 2017, at the age of 23. His dreams, ambitions, aspirations, and goals taken from him by you. He brought smiles to everyone he knew. He left his mark on all of us. I'm thankful justice prevailed so we can start the healing process, to find peace and move on from this painful chapter. Thank you, Judge.
Thank you.